Асель?
Вы их не слышите вообще?
Нурия Олжана, вас видно и слышно.
Dear participants, I would like to express our gratitude for participation in this event. And the topic of this event is the modern digital and HR technologies in the selection and promotion of judges. And today, the governments that managed to develop their legal system will be sharing their experience, and Kazakhstan will also share its own experience. Unfortunately, we do not hear the reporter. The mic is not functioning. Dear English-speaking participants, the mic of the speaker is off and we cannot hear the speaker. So we are trying to address this issue. Thank you for your patience.
Тематика нынешнего форума как никогда актуальна. Цифровые коммуникации.
The agenda of today's forum is very much relevant. Digital informational technologies is the part of our everyday life. COVID pandemic does not allow us to get together in one building, but owing to this new technologies, we can use this virtual platform and overcome obstacles. This year of 2020 is attributive of many challenges and new formats of work. For instance, the Supreme Court of Kazakhstan started using the modern digital technologies, which allowed us to transfer part of the stages of assessment and selection of candidates to remote format. And in this, we were able to find our advantages, since this format saves time and material costs. Also, new ones are becoming more and more in demand. These are HR technologies, and this allows to select the most worthy candidates. We will definitely tell you more about this in details. I'm sure that modern digital technologies, together with HR technologies, was selected as the topic of today's meeting, will give us a good opportunity to communicate and share our experience and in terms of advanced technologies. I believe that we all have a story to tell today. I wish all participants to have a fruitful event.
President of Venice Commission of the Council of Europe, Mr. Gianni Bucchito. Please, Mr. Bucchito.
Hello, good morning or good afternoon for you.
Good morning.
Can you hear me?
Good morning.
Okay.
Мы вас хорошо слышим, спасибо.
Dear Chairman of the High Council, Judicial Council, dear Chairman of the Supreme Court, dear Minister of Justice, ladies and gentlemen, it's a pleasure for me to participate in this international roundtable on the use of modern technologies in the process of selection of candidates for judges. As you are aware, cooperation between the Venice Commission and Kazakhstan started more than 20 years ago. At present, we say that we work together on an important number of issues with different institutions in Kazakhstan, notably the Constitutional Council, the High Judicial Council, the Supreme Court, the Parliament, and the Ministry of Justice. I would also like to take this opportunity to thank our members, Kazakhstan, Mr. Rogov and Mr. Donakov, and others, for their contribution to building these excellent relations. Ladies and gentlemen, the need to ensure the independence of the judiciary and the proper functioning of the judicial system in the interest of society continues to be an important source of activity of the Venice Commission since its creation in 1990. In 2010, the Venice Commission adopted 2 reports on the most important European standards applicable to the judiciary, which constitute a key reference for the Commission in assessing national legislation governing the judicial system and the guarantees put in place to ensure its independent functioning. These fundamental principles were also referred to in several opinions issued upon request from different countries. Among the recurring issues examined by the Venice Commission were the independence and immunity of judges, the appointment and discipline procedures, the composition, mandate, and independence of the High Judicial Councils, and appointments to senior positions in the judicial system. The Commission has repeatedly affirmed that all decisions concerning the appointment and the professional career of judges should be based on merit and objective criteria within the framework of the law. Allow me to refer to some of these essential recommendations. On the issue of the selection of candidates and judicial appointments, I would like to refer to the report on judicial appointments by the Venice Commission, which states that in a number of countries, judges are appointed based on the results of a competitive examination. In others, they are selected from the experienced practitioners. A priori, both categories of selection can raise questions. It could be argued whether the examination should be the sole ground for appointment, or regard should be given to the candidate's personal qualities and experience as well. As for the selection of judges from a pool of experienced practitioners, it could raise concerns with regard to the objectivity of the selection procedures. Choosing the appropriate system for the selection of judges and judicial appointments are real challenges faced by many newly established democracies, especially those where concerns related to the independence and political impartiality of the judiciary still persist. Political involvement in the appointment procedure is endangering the neutrality of the judiciary in these states, while in others, in particular those with democratically proved judicial systems, such methods of appointments are regarded as traditional and effective. It is true that in Europe, methods of selection and the appointment vary greatly according to national legal systems. Furthermore, these methods can differ within the same legal system according to the types of judges to be appointed. I think that in the case of the implementation of the reform of the administrative justice system in Kazakhstan, this is one of the questions that is currently under consideration with respect to administrative court judges, and the answer has to be found in the nearest future in order to make administrative courts fully operational. Another topic of today's seminar concerns the evaluation and promotion of judges. In general, a system on the evaluation of judges is to be welcome. However, it should be stressed that such a system, properly implemented, will consume a lot of time, personal and economic resources to guarantee results that can be relied upon in the long run. In this respect, if a decision is taken to follow this model, new technologies could play an essential role in making this process more efficient. Regular evaluation of the performances of a judge are important instruments for the judge to improve his or her work, and can also serve as a basis for promotion. However, as it was pointed out in the Venice Commission 2011 opinion on the constitutional law on the judicial system and status of judges of Kazakhstan, it is important that the evaluation is primarily qualitative and focuses on the professional skills and personal and social competencies of the judge. There should not be any evaluation on the basis of the content of the decisions, and in particular quantitative criteria such as the number of reversals and acquittals should be avoided as a standard basis for evaluation. Having said so, I would like to note that individual evaluation is far from being considered as indispensable by European judicial systems in general. Countries that have decided not to proceed with an individual evaluation of judges, such as Denmark, England and Wales, Finland, Ireland, the Netherlands, Sweden, and to some extent Spain, have instead developed general performance evaluations of the judicial procedure. As far as the career of judges is concerned, a 2010 recommendation of the Committee of Ministers of the Council of Europe provides that decisions concerning the selection and career of judges should be based on objective criteria pre-established by law or by the competent authorities. Such decisions should be based on merit, having regard to the qualifications, skills, and capacity required to adjudicate cases by applying the law while respecting human dignity. As I have already mentioned, new technologies can be essential in rendering the judiciary more efficient. However, their use should always be conditioned by the respect of fundamental principles and standards, ensuring the independence of courts and the impartiality of judges. Ladies and gentlemen, dear friends, I hope that exchanges such as the one we have today will contribute to the process of reforms in the judiciary in Kazakhstan and in other countries of the region. I can assure you that the Venice Commission remains, as usual, at the disposal of your authorities to continue and further develop our cooperation. Thank you very much for your attention.
Спасибо большое, уважаемый господин Бутитьев. От имени Высшего судебного совета Казахстана хочу выразить Венецианской комиссии и лично вам глубокое уважение.
Council, I would like to express my gratitude for this structural and meaningful response. And without your recommendations on practical implementation, will not only contribute to the operations and performance of our council, but to the adjacent structures engaged in this field. We are ready to continue this cooperation with the Venice Commission, inclusive of the Supreme Law program. The next welcome floor is given to Mr. Bikitaev, and the floor is yours. Dear participants of the round table, first of all, I would like to express my gratitude to the facilitators of the event. Today's international roundtable is related to the message of the Republic of Kazakhstan President and instructions that were communicated within this message, and they are very much relevant. And we need to promote high justice standards and reinforce trust to the court, which is the baseline for independent justice. In current environment, dismissal of the judges that are able to review the cases would be the priority. As of today, the government is keeping in alignment with modern trends and introduces modern HR technologies in selection of judges. We have enrolled new qualification exam being introduced, and we have a multi-staged system for evaluation and assessment of the candidates. And all of this is required to improve the objectiveness of the judicial resources and I believe that the outcomes of this roundtables will significantly contribute to the development of judicial system in the Republic of Kazakhstan. I wish all participants to have an efficient and meaningful event. Thank you for your cooperation in the selection of judges. Next, the floor is given to the chairman of the High Qualification Collegium of Judges of Russian Federation.
Уважаемые участники круглого стола,
Dear participants
разрешите мне от имени
of
Верховного
the
суда
roundtable,
приветствовать всех
let me
участников
on behalf
сегодняшнего
of the
стола. Тема настоящего форума
the topic of this
реалиями современного
forum is
большинство
the
процессов во всех
current
сферах
environment of judicial system. Majority of
для нашей
processes
республики, как и для большинства
for
других
our
стран,
country, similarly to many others, synchronization would be the main priority. And the evidence to that is the initiative of the first president of the Republic of Kazakhstan, Mr. Nazarbayev, about digital Kazakhstan. Implementation of this program contributes to the
устаревших подходов,
accelerated
в том
change
числе
of
и в суде,
existing
в работе судов.
approaches, inclusive
Верховный
of
суд
those adopted within the
последние
courts.
несколько лет активно
And within
внедряет
last years,
судопроизводство,
we are actively implementing
передовые
legal
IT-технологии.
procedures
Сегодня
and
с уверенностью можно сказать,
modern
люди
IT
могут
technologies.
держать на
And we
цифровом
can
контроле все
assure
судебные
you that
процессы
using digital
от подачи
technologies,
заявлений в
people
суд
can
до
control all
окончательного
processes,
разрешения
inclusive
дела.
of
Популярно
applications up
используется
through the
сервис «Судебный
review of the
кабинет».
case. And the judicial
91%
cabinet is
гражданских
a
исков
very
подается в
widely
электронном.
spread service.
6,5 миллионов судебных актов доступны
6.5
через интернет.
million judicial services are available through internet.
Через интернет. Обыденные стали электронные извещения
The
участников
electronic
процесса через
notifications
СМС-сообщения в
are
адрес
sent to
электронной почты.
the participants of
И
cases
самое
to their
главное, в условиях
emails.
пандемии,
And
связанной с
most importantly,
коронавирусом,
in the context
высокий
of
уровень цифровизации в
pandemic
судах
of
позволило полностью
COVID-19, the high
перевести
level of digitalization of
рассмотрение
the
дел
courts
в дистанционный
helped
формат.
to do
Виртуальная
the
канцелярия
hearings in
позволила
the
каждому
electronic
участнику
format,
с
and
любой
the
точки
virtual
мира,
office
где есть интернет,
allowed
подавать
any
заявление в казахстанский суд
participant to the case
с обычного
to
смартфона.
submit their claims to the court
Для
from their mobile
инвесторов
phones.
и лиц, оказавшихся за
And
пределами нашей
investors
страны,
and
коммуникация с
other
нашими
people
судами
who
затруднений не вызывает на
not in
сегодняшний день.
Kazakhstan now have
За
no
время
difficulties
карантина
in
люди
talking
подключились
to the
в
courts.
процессе из
And
20
during
стран
the
мира,
lockdown
и это
period, we had
продолжается и растет.
participants from
Конечно, есть
20 countries of the
определенные
world,
недостатки,
and this is
но
improving.
именно
But of course, there are
IT-решение
some
позволит
drawbacks.
найти
But
максимальный баланс
IT
между
solutions will help to
безопасностью
find
участников
the
процесса
trade-off
и
between the
доступом к правосудию.
security of
Мы
the
понимаем,
participants
что
of
за
the
всеми
process and
этими
access to justice.
нововведениями нельзя
And we
забывать
do
о качестве
understand
работы
that
судов
all these
и
new
судей.
things
В ходе
should
последних
not
реформ,
mislead us. We shouldn't
в
forget
судебной
about the
сфере,
efficiency of the courts.
Верховный
And over
суд
the last years,
совместно с Высшим
the
судебным
reforms were
советом
implemented in the
проработал
judicial
над
sphere,
рядом
and High
комплексных
Judicial
решений по
Council and other
улучшению
bodies
системы
developed
отбора и
solutions,
карьерных
integrated
продвижений
solutions to
судей.
improve
Об
the
этом
recruitment
в
and
сегодняшнем
career
круглом
development of
столе
judges.
скажет
And
моя коллега,
this
судья
will be
Верховного
shared
суда.
by my colleague, the judge of the Supreme Court.
Опробируются
And
современные
we are
HR,
testing the
инструменты,
modern
введенные цифровые
HR
и оценочные
instruments and
критерии
the
отбора
digital
судей.
evaluation
Институционально
criteria for
укрепился
the
Высший
judges
судебный
selection.
совет.
And we
Все
have
эти
seen the
меры
institutional
способствуют
strengthening of
реализации
the High
задач, поставленных
Judicial Council.
руководством страны
And
перед
all these
судебной
measures
системой
help
и
to
Высшим судебным
improve the
советом.
accountability of
Вместе
the
с
court
тем,
system and High
время не
Judicial
стоит на
Council.
месте.
At the
Об
same
этом мы
time,
должны констатировать.
the time is running, and
Процедуры
we
должны
shouldn't forget
совершенствоваться,
about it. The
чтобы
procedures
к осуществлению
must
правосудия
be
были
improved in
допущены
order
самые достойные
to
кандидаты.
make sure that the
С этих
best candidates
позиций
are allowed
было бы
to
интересно
become
узнать
judges.
об опыте
So from
зарубежных
this
коллег,
perspective, it would be good
участников
to know
сегодняшнего
about the
круглого стола
experience
о
of
разработках и
foreign
применении
guests,
современных
guests
инструментов
of the round
отбора и
table on the
подготовки судей.
development and
Надеюсь, что итоги
application of
форума
the
будут иметь
modern
свое
tools
логическое
for
продолжение и
judges training
конкретных
and selection.
результатов.
And I hope
Мы
that we
готовы к
will see
выработке
logical
совместных
continuation
мер.
of this work, and we are
Желаю
ready
всем
to
плодотворной
develop
дискуссии
measures
и
together. And
хорошей
I wish you
работы
fruitful discussion
в
and
данном,
good work
круглом столе.
in
Спасибо.
this roundtable. Thank you. Thank you so much, Mr. Taymyrdenov, and we will continue our cooperation with the Supreme Court to address the challenges. Now, on behalf of the Constitutional Council, the welcoming remarks will be shared by the member of the Constitutional Council, Mr. Mukashev Rahmet.
А где здесь? У меня звука нету. Пусть подойдет.
Звук. Да. Что там? Техническая заминка. Не слышно? Не слышно? Нет. Нет.
There is a technical glitch. Thank you for your patience.
Надо было звонить, Рахиль Зурбаевич.
Рафиз Зурбаевич, вас не слышно. У вас с микрофоном что-то.
Он слышит? Что такое? У нас техническая заминка со связью, мы не слышим нашего коллегу.
We have a technical problem. Unfortunately, we cannot hear our colleague from the Constitutional Council, Mr. Mukashef Rahmet. So I hope that we will hear from him later. Now let me give the floor to Timoshen Nikolai, chairperson of the Higher Qualification Collegium of the Judges of the Russian Federation. Mr. Timoshen, the floor is yours.
Господин Талгат Саидбек,
Dear Mr. Danakov, dear Mr. Taimirdenov, dear Mr. Bukikcho, dear participants of the round table. As entrusted by the Supreme Court of the Russian Federation, from Supreme Court, Mr. Lebedev, I'm speaking on behalf of the Higher Qualification Collegium of the Judges of the Russian Federation. Thank you for giving me the floor at this round table. And we will talk about global experiences in the field of application of new technologies during selection of judges and promotion of judges, all the issues that are handled by the Higher Qualification Collegium on judges. And I'm sure that this will be supported by better legislation and procedures for the formation of the judges' talent pool. And I hope that high quality cooperation between the judicial bodies of our countries, international organizations will continue. And I wish you fruitful work. Thank you, Mr. Timoshen. And I thank the chairperson of the Supreme Court, Mr. Lebedev, for supporting us and cooperating with us. Thank you for this collaboration between Russia and Kazakhstan. Thank you so much too.
Следующее приветственное слово предоставляется Егорову.
Then welcoming remarks will be also shared by Mr. Yegorov Kalmumin, who is the chairperson of the High Judicial Council of the Republic of Uzbekistan. Dear Mr. Danakov, dear participants of the round table, I'm happy to welcome you on behalf of the High Judicial Council of the Republic of Uzbekistan. And let me mention also that the topic of today's international round table is very relevant for the judicial system of Uzbekistan. Given that Uzbekistan has just started active work on implementing state-of-the-art information and communication technologies in the work of courts and also in the work of the High Judicial Council. It's a known fact. The High Judicial Council of Uzbekistan was established in 2017 as the body for the judicial community, and it's a relatively young government agency. And so the use of digital technologies for the recruitment of staff, for the selection of candidates and evaluation of their professional qualities is very much interesting. The experiences of other countries in this matters will be very useful to us. Exchange of opinions and expertise during such events will be another stimulus for our further development of judicial systems, and it will serve a good platform for getting acquainted with the global best examples. And I would like to extend my appreciation to the organizers of this roundtable, and I wish all the participants fruitful work. Thank you.
Благодарю вас, Хамрин. Мы придаем большое значение развитию партнерского.
Dear Mr. Yedgorov, the cooperation with the High Judicial Council is a top priority for us. And last year, there was a roundtable in Astana, which was also attended by the High Judicial Council and Judges Schools of Uzbekistan, and the delegation of Kazakhstan had a working visit to Tashkent to participate in the international conference on the relevant issues related to independence of judiciary. So thank you, Mr. Yedgorov, and we hope for further cooperation between our High Judicial Councils. Now let me give the floor to the chairperson of the Kyrgyz Republic Judges Selection Council, Mrs. Barktabasova Elmira.
Здравствуйте. Здравствуйте, уважаемые участники онлайн международного. Так, извиняемся за немного технические неполадки.
Apologies for some technical issues.
Участники
Hello, dear participants of the online international roundtable. On behalf of the Judges Selection Council, let me welcome you and to thank the Republic of Kazakhstan for arranging this event and for inviting me to participate and speak. The relevance of this event is evidenced by the fact that use of digital technologies by judiciary, including for the judges selection, is one of the key areas of the judges reform that is currently being implemented in Kyrgyz Republic. And in order to implement the reforms, our government spends enough budget for the implementation of digital technologies to enhance the transparency and fairness of the judicial system. ICT technologies help to optimize and efficiently use the information resources of the society and plays an important role in better access of citizens to justice, visibility and transparency of the judicial procedures. And it's equally important to select the candidates who would like to be judges. So in their activities, it's important to use the ICT technologies. It's one of the key components of the professional training of specialists of any profile. Therefore, when selecting the candidates for judges positions, we have to keep in mind such qualities as ability to use ICT technologies in their professional activities. Speaking of the procedure and order of the ICT application will be shared by our representative later on, who is the member of the Judicial Council, Oshokova. So I will not speak too much about that, but at the same time, let me thank you once again for organizing this online roundtable. And let me extend my hope that our cooperation will continue further down the road. And we are happy and we're ready to support collaboration with all the governments of the countries. So let me wish you a fruitful work at this roundtable, and thank you for attention.
Благодарим вас.
Thank you so much, Elmira. High Judicial Council of Kazakhstan values the cooperation with the Republic of Kyrgyzstan. Now let me give the floor to the next speaker. We had a technical problem, so let's go back and let me give the floor to the member of the Constitutional Council, Mr. Mokashov Ahmed.
Dear
Mr. Danakov, dear participants of the forum, the topic of today's meeting is very interesting. In the countries who are going down the path of democratic development, and judicial is important for the rule of law and stability in the society. Over the years of independence, Kazakhstan has done huge work to upgrade the judicial system and judicial proceedings. And in order to implement the plan of the nation offered by the first president, the procedures for case management were established, extended judicial control and specialization of courts. As part of the 100 steps program, requirements to judges have become stricter, and selection and promotion procedures were established in order to have a qualified staff in the judicial system. The current challenges pose new tasks for the judicial, and key tasks are shared in the address of the president, which opened a new stage of the judicial modernization. In any country, judicial should improve, and at the same time, as the international practice shows, judicial should be somehow conservative too. That's why in this linear process, we have to ensure succession and consistency of the measures taken. Recently, in one of the opinions, the Venice Commission has underlined that the principle of stability and consistency in law as the key element of the rule of law requires stability of the judicial system. And in the Venice Commission's opinion, instability when reforms are following the political power changes may pose a threat to the public trust to the judicial system as the independent and impartial institute. And in judgments, it's important that the judges would be guided by the constitution and law. Any interference with the judges' cases management is not allowed. So the impact on the judges and even legal impacts and interference with the ethical norms enforcement is not allowed. So in terms of recruitment, promotion and dismissal of judges, last year an important role was played by the High Judicial Council, which is applauded, and the work in this direction should continue. Only people with high professional qualities and with good morale can be accepted for the judges' positions. And according to the law, judges should be governed by the constitution and then the law. And if there are such justifications, the judges should be able to stop the proceedings and ask the Supreme Court about the legitimacy, and this requires a very active position on the quality of legislation, which depends on the level of the constitutional outcome. And when the judges are selected, I think that the focus should be made on these aspects too. And special attention should be paid to the application of digital technologies in court proceedings, and also the tough policy in judicial, and to be to go hand in hand with the modern trends as part of 100 steps program. Now all the judicial has become digital, and this helps the integrity of the processes in the context of pandemic.
And supporting this direction, I believe that digitalization of the judicial power should be in compliance with the justice principles. It's not a secret for anyone that quality of internet, especially in rural areas, is not always satisfactory to the demand. And the Constitutional Court in this year has re-emphasized that deeper digitalization for specific areas of governmental power does impact directly some constitutional targets of human rights, and implementation of new mechanism for selection of judicial resources would be the baseline to reinforce trust of community implementation of the rule of law. And from this perspective, establishment of and arrangement of this roundtable provides great opportunity to exchange experience and elaborate acceptable solutions. And I wish you to have successful event. Thank you very much. And we wish our Constitutional Court to have great success in the reinforcement of the law. Next, the floor is given to Mr. Jakub Berish, resident representative in Kazakhstan, the main co-organizer of the roundtable. I ask you to the floor, Mr. Berish.
Thank you very much, Chairman Donov, Minister Beketayev, distinguished guests and participants. It's an honor to welcome you today at the International Roundtable dedicated to the modern digital technologies in the selection of candidates for judges. I'm pleased to be here. For almost 3 decades, we have been supporting Kazakhstan's efforts in justice reforms. One of the key priorities of Kazakhstan is to improve the judicial system to meet the needs of the Kazakhstan society and protect the rights of and freedoms of citizens. This process is inextricably linked to the formation of judges. This is possible by creating a transparent and effective system for selecting candidates for judges. We very much appreciate the efforts going into this important area of the reform, once again prioritized by President Tokayev in his recent State of the Nation address. This roundtable is held as part of an important initiative jointly implemented by the High Judicial Council, the Ministry of Justice, and the United Nations Development Programme. I take this opportunity to thank our partners for an excellent and productive collaboration we have enjoyed over the course of the past 2 years. I would also like to thank the World Bank that made the funding available through the World Bank loan. We enjoy strong institutional partnership with the World Bank globally, and we are pleased to join the work on concrete initiatives on the ground here in Kazakhstan. We are pleased that the good example and experience we had here in Kazakhstan are actually replicated elsewhere. Over 2 years of implementing this initiative, we made significant progress in promoting new approaches for the selection of judges. We take pride when we see that they have contributed to institutional strengthening of the judicial recruitment system. Of course, the real work belongs to our partners, particularly the High Judicial Council. We can only applaud their efforts to be on par with advanced judiciary systems through introducing modern approaches in staff selection. Building on this experience, UNDP stands ready to continue supporting such important initiatives in the area of judiciary reforms in the future as well. Let me now turn to the future. Our country program for Kazakhstan, which covers 2021 to 2025, was approved recently in September 2020, after broad consultations with government partners. So rule of law and justice sector reforms are at the core of our plans for the next 5-year period, and we hope to continue working together with partners to achieve those plans with concrete results for the country and its people. This dialogue platform that we participate today is becoming an effective tool for exchanging experience for further modernization of the judicial system of the participating countries. I'm glad to note that the work is paying off, and this platform has actually increased its importance both at the regional and international level since the last roundtable. On that note, I wish you further success in promoting such exchanges, and for today, I wish all participants productive discussions and deliberations on this reform topic. Thank you very much.
Господин Берич, мы признательны офису ПРООН за содействие и помощь, оказываемую нам в деле модернизации системы отбора и продвижения судей в Казахстане. Мы готовы к дальнейшему сотрудничеству. Уважаемые участники и гости круглого стола, также позвольте поприветствовать наших зарубежных партнеров, принимающих активное участие в работе нашего форума. Мы приветствуем сегодня Серика Кабута, члена Высшего Совета магистратуры Французской Республики, Кристофера Холл, регистратор, исполнительный директор суда ФСА, Исоков Живата Истролович, заместитель председателя Высшего судебного совета Республики Узбекистан, Азизода Зафар Нусрат, председатель коллегии по уголовным делам Верховного суда Республики Таджикистан, Агозода Ахор Саибот, судья Верховного суда Республики Таджикистан, члена Судебного совета Литовской Республики Инес Сагатис и Гидию Тамшунена и Йовиту Рамаускена, члена Совета по отбору судей Кыргызской Республики Сапубеку Назиру Толоновну и старшего менеджера Международного отдела комиссии по отбору судей Англии Шарлин Гордон. Рады приветствовать вас, уважаемые коллеги. А теперь
Selection Commission. Now let's move to the main part of the round table. We suggest the following procedures to be observed. The keynote speech up to 15 minutes, speeches up to 10 minutes each. We suggest to hold discussions after presentation, and we will have 30 to 40 minutes dedicated for that. Dear colleagues, I have to say that taking the work schedule into consideration, we had to introduce some changes into the order of our speeches, and I hope you will understand this. So the floor is given to the expert of Venice Commission, Slavika Banic and George Papuashvili, and they will be sharing the features and selection assessment tools for judges, information of administrative courts, and sharing international experience. So the floor is over to you.
Is it okay now? Yep. Дорогие коллеги, я приветствую вас всех из Загребия, и я желаю вам успеха в дальнейших усилиях по работе, из-за которой сейчас на собрании. Так как мой русский не хороший, я продолжу на английском. And I truly hope you understood something of what I said. So now allow me to present Venice Commission's findings related to the topic from agenda. After review quite a number of countries' legal framework in relation to administrative justice, our report first of all showed that all countries situate administrative justice in the judicial branch of power, and almost all require appointment of judges in order to review the administrative disputes at the courts. However, the review shows that there is no unique approach for organization of judicial system in that regard. Namely, some countries have administrative courts as specialized courts, while others empower ordinary courts to deal with administrative issues. There are those countries which combine these two models. For example, in Czech Republic, ordinary courts deal with administrative matters at the first level, which may be appealed to the Supreme Administrative Court as the specialized court. While in Estonia is quite opposite. There are administrative courts at the first level whose decisions may be appealed to general courts. Analysis also has shown that almost all countries make no difference in procedure of the appointment of judges in relation to administrative and ordinary court judges. This is the case in Slovenia, Serbia, Estonia, Croatia, Finland, Germany, etc. However, it is quite common to provide additional requirements for them in the case of the election of judges to higher courts. The recruitment system, though, varies from country to country. It is necessary to mention that there is almost no political appointment of judges. If it exists somewhere, it is provided for the highest courts or for constitutional courts. The other two systems of recruitment refer to the one which presumes completion of judicial academy or other relevant school in order to become eligible candidate for judge. In these institutions, it is conducted practical and theoretical education and training for judges for a certain period of time, which at the end requires the examination. The second system is the one which allows the direct access to judicial position, provided previously acquired experience in legal profession. Again, in relation to this aspect of selection, there are countries which combine both models. Most of the European countries nowadays follow the first system, meaning recruitment after attendance of judicial academies. Among them, to mention an approach of my country, is that until 2010, Croatian judges were appointed on the basis of the public qualification competition for all practicing lawyers. Today, Croatia follows the example of countries with the so-called civil service system, where judicial appointments depend upon the completion of the state school for judicial officials who passed respective state exams. But this system is highly criticized in Croatia due to many shortcomings related to final evaluation of candidates. Speaking about the manner on the appointment procedure, all countries foresee the public qualification competition. In that regard, the conditions depend on the selection system. Namely, in the countries which opted for institutional formation of judges, the candidates are young law school graduates whose selection is merit-based, which means that it is acquired fulfillment of certain conditions, such as the success at law schools, abilities and personal characteristics necessary for working as a judge, state exam, etc. On the other side, countries which have the direct entry to judiciary, which implies that all kinds of legal professions are able to candidate, the competition is also merit-based, but the examinations is focused on already acquired professional skills, years of experience, publication, specialization, etc. The direct access system imposes different additional examination related to the abilities to comply with judicial activities. They come in the form of structured interviews, psychological tests, performance of legal opinions, etc. The identification of skills and abilities varies. Let me mention here Lithuania as a country which has rather detailed regulations on requirements for the appointment of judges. Having in mind that administrative justice in Lithuania is handed to regional administrative courts and the Supreme Administrative Court as the appeal court, Evaluation of candidates for election of regional administrative courts judges relates to work in legal area and personal competencies. For the evaluation of the work in the legal area, the detailed parameters are provided. They refer to the nature and quality of the work, the professional activity in the sense of quality of legal work, the nature and quality of scientific work, professional competence and knowledge, knowledge of foreign languages, university education other than law, a professional development and improvement, participation in expert activities like drafting skills, participation in the working groups, in public activities related to justice, as well as all other activities of the candidate related to the acquisition and deepening of the knowledge necessary for the work of a judge. Personal competencies, though, are aimed in evaluation of constructiveness of the candidate's thinking, erudition, personality, maturity, emotional balance, effectiveness, and objectivity of decision-making, duty and responsibility, the ability to effectively organize one's work of others, communication and cooperation skills, etc. In Georgia, the skills are evaluated through knowledge of legal norms, ability of legal substantiation and competence, writing and verbal communication skills, professional qualities, academic achievements and professional training, professional activity. To conclude with this aspect, I should say that while many countries foresee the possibility for the appointment of highly qualified lawyers as judges through the system of the direct access to the judicial system, none of them allows it without respective public qualification competition. One of the expressed concerns in preparatory materials referred to the assessment of the knowledge of already active judges in the case of transfer from ordinary courts to the administrative courts. Allow me here indeed to refer to Croatian approach in that regard, which seems quite suitable for the Kazakh's future experience. Namely, in 2012, Croatia experienced a big administrative justice reform, which introduced 2 levels of administrative justice, which until 2012 existed only on 1 level. The then existing administrative court, which reviewed only legality of administrative acts, suddenly became High Administrative Court, and all its judges automatically became High Administrative Court judges. Other 4 first-level administrative courts were introduced with a task to conduct oral hearing and establishment of facts in relation to administrative acts. The transfer for judges from civil and criminal courts was possible without any additional testing and dependent only on consent of the judge in question. And of course, they had to submit candidature for the competition. The civil and criminal court judges were even encouraged by high judicial officials to apply because it was thought that already experienced judges, regardless of specialization, could adapt better to new situations than the candidates outside of judiciary, although it must be said that the competition was also open to everybody, including civil servants or attorneys at law or any other legal profession. Last but not least, in relation to assessment of the knowledge, it is noticed that all reviewed countries, regardless of the appointment procedure system, establish the training institutions for the active judges. In some countries, the training and further education is obligatory, while in others, it is of optional nature. Let me mention again Croatia. For example, Judicial Academy provides the training for judges, which is not obligatory for them. However, if a lower court judge has aspirations to advance in the career, meaning to come to the higher court, the activities of this kind are reviewed and evaluated. So I will finish here and let my colleague George Papashvili to present the other part. Thank you very much for your attention.
Пожалуйста, господин Папашвили, внимательно слушаем, Георгий Эдуардович, пожалуйста.
Спасибо, приветствую всех, господин Талгат Данаков. Я рад, что сегодня есть возможность подключиться к вам. Приветствую всех ваших гостей. Я очень коротко, потому что уже Славица большую часть уже она передала, и наш репорт от Венецианской комиссии послан детальный, более детальный, где более детально говорится о тех вопросах. Я буду акцентировать мою речь на английском, но вкратце значит, более по критерию, как есть добропорядочность. Вот по этому критерию я вкратце передам, значит, наши идеи. Administrative courts in some countries act as a separate branch of the judiciary, where the Assembly of Administrative Judges has special functions, like in Poland and Austria, or functions related to the selection of judges in other countries. The administrative courts act as chambers or collegiums in the general courts, like in Georgia. There are also combined systems, which also Slavica mentioned, where the administrative courts are separated from the general court system only on some levels of jurisdiction. For example, in Estonia, where the first instance cases are decided by the separate administrative courts, but ordinary courts act as the appeal instance. However, usually when judges are selected, be it administrative or general courts, the selection bodies use the objective criteria set out in the law. Basing the choice on the objective selection criteria can be seen as the most important measure to check the integrity of the candidates. On the other hand, the well-defined criteria raise public trust in the appointment procedure. In Georgia, for example, a candidate for judge, including the administrative judge, shall be selected based on two basic criteria: good faith and competence. And the characteristics of a good faith criterion shall be as follows: personal good faith and professional conciseness, independence, impartiality, and fairness, personal and professional behavior, and personal and professional reputation. It needs to be noted that for the criteria to be effective, there needs to be several procedural mechanisms. Firstly, each criterion should ideally be rated using the point system. Secondly, the activities related to the appointment of the judge or the act of denying to appoint of the relevant candidate on the position of the judge should have the legal reasoning that is essentially stemming from the objective criteria set by the law. Thirdly, it's important to have the appeal mechanism. For example, in the same Georgia, if the candidate is denied, they can go to the qualifications chamber of the Supreme Court with the appeal. If they think that member, for example, if the member of the High Council of Justice was biasing during the competition or had discriminatory attitude, etc. After hearing, the qualification chamber of the Supreme Court either shall uphold the decision of the High Council of Justice on refusing to assign the candidate for judge to the position of judge, or shall revoke the decision of the High Council of Justice on refusing to assign the candidate. It's important to know that usually the measures to check the integrity of the candidate, along with the criteria, are included in the procedure of selection. For example, in many countries, the relevant selection body would look for information related to the candidate. That may include information about honesty, for example, if the candidate has any minor offenses or if the candidate has unpaid financial responsibilities, and so on. The rule not to appoint the persons who have been removed from their judicial position after the disciplinary procedures are quite common. In some countries, it has special time terms. In others, it only extends to the candidates to the chairman of courts. However, it needs to be said that these measures altogether constitute the adequate safeguards for the appointment of the worthy judges. It needs to be noted that initial training is an important element of integrity also. Theoretical and practical pieces of training are supposed to increase not only legal knowledge and competence, but also the integrity of the candidate. The practical training element is very common around Europe. And as I know, we will have the pleasure to have examples of Spain and France today. But I will mention just briefly about our neighbors, Ukraine. The practical training, one example would be Ukraine, where before the appointment, there is the selection examination. Selection examination is conducted by High Qualification Commission in the form of anonymous testing to check the general theoretical knowledge of the candidate about the law, the command of the official language of the country, personal moral and psychological qualities of the candidate. There is an initial training requirement as well. Special training shall be conducted for 12 months, unless another term is defined, at the expense of the state budget. The term of special training at the National School of Judges shall be added to the record of professional activity in the field of law. The program is focused on quality training of candidates for the position judges before they perform the official duties of a judge. The program also includes theoretical and practical training, internship in local courts, study visits to the prosecutor's office, bodies that carry out pretrial investigation, and topics of theoretical practical part of the special training are combined in modules and blocks. To sum up, the measures for the integrity of the candidates are clear and objective appointment criteria, relevant appointment procedures, general requirements for candidates that can filter the candidate's integrity, of which may be questioned, and initial training of the candidates. All these measures are effectively used in the judicial appointment procedures around Europe. It needs to be noted that these measures should be as effective as possible. For example, the appointment procedure should have safety mechanisms like the legal reasoning of the decisions and the appeal mechanism. Спасибо большое, это очень вкратце, чтобы оставить время и для других выступающих.
Позвольте поблагодарить вас, госпожа Банич, и вас, господин Папашвили.
Mr. Papashvili and Mrs. Banic, for your informative presentations. This year, the president of our country, Mr. Takayev, has mentioned in his address that our procedural code must provide for the new administrative court. So the information that you shared is quite practical. So thank you very much for that. Now let me give the floor to the next speaker, our guest from France, Mr. Renard. He will talk about the framework of competence in the training of future judges and prosecutors.
Merci beaucoup, Monsieur le Président. Bonjour à toutes et à tous. Je vais m'exprimer en français puisque cette possibilité m'a été offerte. Je m'appelle Élie Renard, je suis le directeur adjoint de l'École nationale de la magistrature basée à Bordeaux et à Paris, et je me trouve actuellement dans les locaux parisiens, et vous apercevez derrière moi le chantier du site de la reconstruction de Notre-Dame, pour ceux qui connaissent notre emplacement et que nous avons déjà eu le plaisir d'accueillir. Merci beaucoup aux autorités du Kazakhstan de nous avoir conviés à cette réunion. Un merci tout particulier au président du Haut Comité judiciaire de la République du Kazakhstan, M. Taglat Donakov, qui vient de me donner la parole et je l'en remercie. Nous gardons tous au sein de la délégation française un excellent souvenir de l'accueil que vous nous aviez réservé en octobre 2019 et nous espérons sincèrement que nous aurons prochainement l'occasion de vous accueillir à notre tour à Paris ou à Bordeaux si vous le souhaitez. Je salue également le précédent intervenant avec qui j'avais eu le plaisir de discuter à cette occasion. Je vais vous dire quelques mots des enjeux de la compétence des juges et procureurs en France et la manière dont nous les formons. Je vais procéder en 3 temps en évoquant d'abord le contexte dans lequel nous nous inscrivons, qui est un contexte, vous le savez, européen. J'évoquerai ensuite le contexte français avant d'évoquer un peu plus précisément avec vous les questions pédagogiques. Sur le contexte européen dans lequel nous nous inscrivons, eh bien, les principes de formation judiciaire sont actés au niveau du réseau européen de formation judiciaire dans un document qui date de 2016 et qui liste les grands principes de la formation judiciaire. Il y en a 9, parmi lesquels le fait que cette formation judiciaire doit être une formation pratique et pluridisciplinaire qui vise principalement à la transmission des valeurs et des techniques professionnelles qui sont le complément de la formation juridique. Donc, l'enjeu essentiel de la formation judiciaire est une formation sur les pratiques professionnelles. Ce n'est plus que du droit, ce sont vraiment des enjeux extrêmement pratiques. Je ne vais pas vous énumérer tous les principes, mais les grands enjeux sont que, d'une part, les magistrats, les juges et les procureurs doivent se former en formation initiale avant leur nomination, mais également en formation continue tout au long de leur carrière. Et un des autres grands enjeux, c'est que les axes pédagogiques et le contenu des formations doivent être décidés par les plus hautes autorités nationales compétentes en matière judiciaire, en particulier le Conseil supérieur de la magistrature, dont les représentants sont également les chefs de cour de la Cour de cassation, qui est la plus haute instance judiciaire du pays. Et ce sont d'ailleurs eux qui président le conseil d'administration de l'École nationale de la magistrature. Un des autres grands enjeux des principes de formation judiciaire au niveau européen est que les formations doivent être en grande partie dispensées par des juges et des procureurs en fonction. Autrement dit, on est vraiment dans des enjeux de transmission de pratiques professionnelles extrêmement concrets qui permettent de transmettre le savoir-faire, mais aussi ce qu'on appelle le savoir-être, c'est-à-dire les positionnements professionnels et notamment et en particulier, bien évidemment, les enjeux qui relèvent de la déontologie, qui est au cœur de nos enseignements. Ça, c'est le contexte européen dans lequel s'inscrit l'action de l'École nationale de la magistrature. Le deuxième temps de mon intervention consiste à aborder avec vous les enjeux en France plus particulièrement, puisque nous travaillons en formation initiale comme en formation continue autour des compétences fondamentales que nous essayons de développer chez nos magistrats. Ces compétences fondamentales, ce sont celles qui nous permettent de transmettre les valeurs communes des juges et des procureurs, c'est-à-dire les valeurs d'indépendance, d'intégrité, d'impartialité, de loyauté. Et nous construisons nos enseignements autour de 13 capacités fondamentales que je peux rapidement évoquer avec vous. C'est vraiment le cœur des enseignements des magistrats, des juges et des procureurs en France, c'est-à-dire d'abord la capacité à comprendre et à intégrer les règles déontologiques, les capacités d'analyse et de synthèse de situations complexes et en particulier de dossiers complexes, la capacité à respecter les règles de procédure et les cadres procéduraux, la capacité d'adaptation, qui est une des conditions et des compétences exigées des juges et des procureurs, la capacité à adopter une position d'autorité, une position d'humilité en fonction des circonstances, la capacité à l'écoute et à l'échange, la capacité de respecter le contradictoire et donc la contradiction, l'échange de vues sur les dossiers, la capacité de conciliation également, les compétences juridiques, la capacité à travailler en équipe et la capacité de prendre en compte l'environnement international, qui est également un enjeu très important pour nous. Alors, comment est-ce qu'on fonctionne là-dessus? Comment est-ce qu'on développe ces compétences chez les magistrats français, que ce soit en formation initiale ou en formation continue? La méthodologie qui est portée par l'École nationale de la magistrature peut se résumer sous 3 angles fondamentaux. Le premier, c'est que nous travaillons principalement autour de méthodes de pédagogie active et pratique. J'évoquais tout à l'heure le fait qu'il s'agissait de formation professionnelle sur les pratiques professionnelles. Eh bien, nous essayons de refléter cet enjeu dans les formations que nous dispensons en essayant d'avoir les échanges les plus concrets possibles sur des pratiques professionnelles et notamment en développant beaucoup, en particulier en formation initiale, les mises en situation. Nous sommes donc dans des enseignements qui ne sont pas descendants, verticaux, théoriques, ce sont vraiment des mises en situation pratiques sur la manière dont nous pouvons fonctionner et dont nous travaillons en tant que magistrats. Les jeunes magistrats en particulier effectuent sur leurs 31 mois de formation initiale des stages d'une durée de 21 mois. Donc la majorité des enseignements sont des enseignements pratiques sous forme de stages, y compris d'ailleurs dans des cabinets d'avocats, également bien entendu en juridiction, mais aussi par exemple dans des services de police ou encore au sein des services pénitentiaires. Les enseignements donc ont vocation à être pratiques autour de principes de pédagogie active, c'est le premier axe. Le deuxième axe des enseignements que nous développons, eh bien, c'est ce que nous appelons en France l'approche par compétences, qui recoupe des enjeux pédagogiques évidemment internationaux. C'est un sujet que nous développons beaucoup ici en France. C'est un sujet de grande actualité pour une raison très simple, c'est que la magistrature française est dans une démarche d'ouverture et notamment nous sommes en train de diversifier grandement nos recrutements. Traditionnellement, vous le savez, c'est une des spécificités du système du droit continental et c'est particulièrement vrai en France. Les juristes qui sont recrutés pour être juges ou procureurs peuvent débuter leur carrière en tant que jeunes juges ou procureurs dans des âges parfois très jeunes, autour de 25 ans, 30 ans. On peut démarrer une carrière en tant que juge ou procureur. Nous sommes en train de diversifier nos recrutements pour permettre à un plus grand nombre de profils de rejoindre les rangs de l'autorité judiciaire en recrutant notamment des professionnels qui ont exercé d'autres métiers, des professeurs de droit, des enseignants, des avocats. Et il faut que nous eh bien, leur permettions d'effectuer cette transition professionnelle. Et donc, nous travaillons beaucoup autour des principes de l'approche par compétences qui vise à organiser toute notre pédagogie autour des compétences que nous souhaitons développer. C'est un travail pédagogique très intense que nous sommes en train de développer en formation initiale et également de manière très rapide en formation continue. Troisième principe, grand principe des orientations pédagogiques de l'école, c'est ce qu'on appelle l'interprofessionnalité, c'est-à-dire que nous travaillons beaucoup sur la possibilité et les capacités des magistrats, des juges et des procureurs à comprendre l'ensemble des enjeux des professions avec lesquelles ils travaillent, que ce soit les greffes, les personnels des juridictions, les avocats bien sûr, les policiers, les gendarmes, mais également bien au-delà sur l'ensemble des partenaires des institutions étatiques et également sur l'ensemble des professions du droit. Cela fait partie des grands axes de la pédagogie que nous déployons. Alors, quelques mots de conclusion. Parmi les enjeux actuels que nous identifions, eh bien, un des principaux, évidemment, c'est de pouvoir continuer à porter ces enjeux pédagogiques dans l'espace numérique. Nous le savons et vous le constatez, les échanges à distance permettent de faire de très grandes choses, mais il faut y adapter de manière très fine la pédagogie que nous portons et cela fait partie des grands enjeux du moment, comment former aux pratiques professionnelles à distance. Ça fait partie des grands défis que nous avons collectivement à développer. Nous travaillons également sur la définition d'un meilleur équilibre entre les compétences strictement juridiques des magistrats et tout le reste, c'est-à-dire ce qu'on appelle les soft skills. Cela fait partie également des grandes pistes de réflexion actuellement en France. Je vous remercie de votre attention. Je vous remercie de la traduction simultanée qui a été fournie. Je me réjouis de participer à vos échanges et j'espère avoir très vite l'occasion de vous revoir en vrai. Merci à toutes et à tous.
Благодарю вас за выступление, господин Ренар. Хотелось бы отметить, что Высший судебный совет Казахстана высоко ценит сотрудничество с Национальной школой магистратуры Франции.
Really values the cooperation with the National School of Magistrates in France, and experience of France is very relevant and highly demanded. Now let me give the floor to the Unfortunately, the sound is very poor.
И в условиях пандемии COVID-19. Прошу вас. Слово представляется господину Челентано, президенту
Mr. Celentano, President of the High Council of Magistrates of Italy.
Thank you. Thank you all. First of all, I would like to express the gratitude of the Italian High Council of the Judiciary to the Chairman of the High Judicial Council of the Republic of Kazakhstan and to all other members of the Judicial Council for the opportunity to take the floor in this interesting roundtable. I thank you all the authorities of the Republic of Kazakhstan. I bring you the warmest greeting of the CSM, and in particular the greetings of Vice President David Dermini, who delegated me as President of the Ninth Commission entitled to promote and take care of international activities of the Council. A warm greeting to all the participants. I am disappointed that my participation in the roundtable will be limited due to urgent commitments, so my speech will be short enough. We know in general that the modernization of all judicial administration can be seriously improved through the correct use of information and communication technologies, database and networking in courts, with the development of better communication with the relative judicial training and professional development. This is a trend whose goal is essentially to improve decision-making and productivity by shortening the decision time, enabling a more efficient resolution of all cases, allowing effective planning of human resource employment and different courts. This kind of reforming process in Italy was in last month further improved due to the needs of facing COVID-19 pandemic spreading. The technological approach used in last years in civil courts, as an example, was useful not only to improve the performance, but to manage the human resource during the pandemic distancing measures. In many aspects, the PCT, which is a chronic or telematic civil trial experience, was exported and further implemented, as an example, to the Court of Cassation. In this court began an official testing phase for deposit of documents and was developed an application for the management of telematic procedures of documents filed digitally by the lawyers. This application will allow the visibility of the electronic files to judges who are members of the College of the Court of Cassation and to the Attorney General, so that council chambers can be held without the presence of judges and the decisions can be taken remotely via video conference. This kind of approach in the use of technology was held also in the organization and in the activities of the self-government body, CSM. In this case, it has to be clear that for many years, the Council of the Judiciary, CSM, developed a digital database platform to manage documents, files, and procedures regarding judges and prosecutors, their careers, and their appointment to directive functions. Since the first years of the second millennium, the CSM adopted technology oriented not only to the office automation and database technology, but also to the networking interconnection between the central self-government decisions and the local districtal councils. It was soon clear that office automation could have used mostly for document production to increase the use of standard text, but not to manage better the procedures involving the evaluation of the judge's career. So a database technology was implemented to achieve an electronic personal file for each magistrate, judge, or prosecutor, whose content was available for all pending procedures before the council. In the meantime, all this electronic information were available on a web-based intranet. Networking technology was in their regard fundamental to communicate each other electronically between courts staff, including judges, districtal councils, and the council. The main example of this improved technological human resource management could be found in the case of periodic evaluation of professionalism of judges and prosecutors. It has to be known, in fact, that the professionalism of judges in its various profiles is subject of repeated and in-depth checks during the entire length of their professional life. The delicacy of the functions performed by the magistrate requires to constantly verify that the attitudes evaluated at the beginning in the first election remain throughout the judge's service period. It's evident that the activity in this regard has to face a huge amount of files, documents, and evaluation parameters, because every 4 years, hundreds of procedures has to be defined and hundreds of evaluation has to be done. The procedure is extremely complex because the evaluation covers the entire 4-year period, is based on many evaluation parameters: independence, impartiality, balance, capacity, commitment, diligence, industriousness. At the end of the evaluation period, the Judicial Council acquires and evaluates information available at the Superior Council of the Judiciary to the Ministry, the report of the magistrate on the work, the statistics of the work performed, the report and the reports coming from the head of the offices, which must be taken in account to specific situations represented by third parties too. The Judicial Council may take information on specific facts reports by its member or by the head of the offices. On the basis of all these acquisitions, the Districtal Judicial Council formulates a reasoned opinion of the High Council for the Judiciary, together with the documentation and the minutes of the hearings. All these phases proceed through the electronic personal file of the magistrate, the intranet services, and documents and reports are digitally mastered so that the final decision of the CSM can be timely and accurate. In the same way, the Council manages via an intranet procedure all the cases related to the conferral of the directive functions. The appointment of magistrates at the top of judicial offices is one of the most important and delicate prerogatives of the CSM, and technological and IT approach is extremely useful to guarantee plenty of information to the fifth committee to the Council. Also, in this case, all the phases of the procedure are managed by IT and networking. The magistrate inserts the application and any useful information, documentation into the intranet. The Districtal Judicial Council complete the file via its evaluation data, and finally, the board electronically obtain a series of elements on the basis of which to express its final judgment. Obviously, the choice is made on the basis of a competitive procedure, which has the objective of comparing the aspirants on the basis of a knowledge, resources, and select for each office to be covered the most suitable candidate for aptitude and merit. having regard to the functional needs to be met and were resisting to particular environmental profile. Many of these digitally mastered evaluation of the data management in recent years have been further improved, but the last year pandemic problems unexpectedly forced the Council to face the problem of self-government decision in absence. To guarantee the participation of the meeting of the plenary assembly, the CSM modified its self-regulation with the provision that the presidency can authorize the individual member at their request to participate in the meeting of the plenary assembly remotely via telematic connection. The participation is implemented through the use of computer technologies such to ensure identification of the visual, and each participant have the possibility to voting to use his voting expression rightly. To those who participate reportedly in works of plenary assembly, referring commission or other board members is allowed to knowledge of documents of each procedure by sending an electronically file form. In this case, the IT and networking technology during pandemic era demonstrates that the path already taken in the past has made it possible to tackle, in terms of efficiency, the particular condition of difficulty in making decisions in person. I stop here my summary contribution, and I thank you all for your attention.
It's for a very meaningful report, and also express our respect to Mr. Ermini for assistance in establishment of bilateral cooperation within the memorandum of Italy authorities. We believe that your experience in implementation of the modern tools and technologies will be very much useful to our country. Next, the floor is given to the head of OSCE ODIHR department, Mr. Francisco Cardona, expert in the field of public administration, and the one who owns the experience in the field of appointment of judges and administration of administrative courts. Please, let's welcome Mr. Cardona.
Thank you very much. First of all, let me introduce myself. My name is Konstantin Orzelashvili. I'm chief of the Legislative Support Unit, as it was already mentioned. Dear Chair of the Judicial Council, Presidents of the Supreme Court, ministers, ladies and gentlemen. First of all, I would like to thank the High Judicial Council and Chairman Danako for this kind invitation to attend this very interesting and to take part in this very interesting event. It is our pleasure and a privilege to be able to take part in the discussion and provide assistance in this extremely important judicial reform. ODIHR and Kazakhstan authorities enjoy productive cooperation for many years already, and in many various areas, including legislative and judicial reforms, following the requests received from various public institutions, including the High Judicial Council or the Supreme Court and the Ministry of Justice. ODIHR has developed and published about 30 legal opinions, provided other forms of assistance directly or with the support of the OSCE Program Office in Nur-Sultan. This particular case, following the invitation from Mr. Danakov, ODIHR is particularly delighted to provide an overview of relevant international standards and good practices applicable to the reform of the administrative courts. The comparative review is being prepared now and will be submitted shortly after this event, which will also give us a possibility to reflect on some of the interesting issues being discussed today. In this work, we are supported by international experts on public administration, Mr. Francisco Cardona, who will speak after me and will provide a little bit of more detailed overview of the standards and the good practices. the speakers before spoke about the different models of administrative justice and different models in which can be applied, and they are applied in different states. Similarly, ODIHR intends to review a number of state examples, and as I mentioned already, Mr. Cardona will speak about them. However, when referring to national legislation and practices, ODIHR does not advocate for any specific country model. It rather focuses on providing clear information about applicable international standards while illustrating how they are implemented in practice in certain national laws. Any country example should always be approached with some caution, since it cannot necessarily be replicated in other countries. These examples should always be considered in light of the broader national, institutional, and legal framework, as well as country context and legal culture. Solid and effective judicial review serves the general interest of a public. The fact that the judge can annul an administrative decision and oblige the administrative authority to redress an unlawful situation is the utmost expression of the rule of law. It is also the most genuine means of ensuring that all public authorities are effectively subject to the law and that citizens have their rights guaranteed when facing governments and administrations. When judicial ruling annuls a legitimate or illegal administrative decision or obliges the state to compensate the wronged citizen, it does not diminish the efficiency or prestige of the public authority or of the government. It's on the contrary, such ruling contributes to improving the quality of the public administration and improve the trust of the judicial system. It is therefore of utmost importance that judicial institutions, as well as individual judges dealing with administrative appeals, must be able to exercise their professional responsibilities without being influenced or fearful of arbitrary disciplinary investigations or sanctions from the executive or legislative branches. Thus, the principles of independence of the judiciary becomes essential for public trust and credibility and efficiency of the judicial system. A functioning justice system is a fundamental element, and various bodies and institutions of the United Nations or on regional level, as we heard on the Council of Europe level, the bodies of the institutions of the Council of Europe developed set of recommendations on this relevant to the selection and appointment of judges. The OSCE participating states have also consistently indicated a strong commitment to protect and guarantee the rights of individuals. 1990 Copenhagen document and 1991 Moscow document. In these documents, OSCE participating states have committed to ensure the independence of judges and the impartial operation of the public judicial services. It's one of the elements of the justice. In Moscow document, participating states further committed to respect all international standards that relate to the independence of judiciary. Further and more detailed guidance is provided by the ODIHR Kiev recommendations on judicial independence in Eastern Europe, South Caucasus, and Central Asia. OSCE countries have indeed established a varying system of administrative judicial review. But while speaking about the administrative review, we should also be cautious of and bear in mind the procedures which precede the judicial appeals. Generally, the interested parties may be obliged to exhaust administrative remedies prior to engage in a procedure before the court. It is therefore important to ensure that these administrative remedies are also in line with the international standards, that they are not too lengthy or not too burdensome, thus preempting recourse to the court. In general, provisions of prior use of administrative remedies are regarded as useful, but as they will diminish the workload of the courts, and they will may be useful as far as they will provide rapid remedies to the interested persons. But as mentioned, they should be in line with the international standards. I will wrap up here and would hand floor to our expert, as mentioned already, to Mr. Francisco Cardona, and at the same time. I'd like to say that ODIHR stands ready to continue supporting high judicial councils and other relevant authorities in this important reform process. Thank you very much.
Hello, good morning to everybody. I would like to take the opportunity to thank for the invitation and also to greet my old acquaintances in Kazakhstan, starting by Mr. Drakov, and all the experts with whom I have coincided in previous events and international discussions. I would like to use the a screen, this, on international standards in appointing judges, because I want to focus very strictly on that. It has been already mentioned that there sorry. There are several models of appointing judges. The models, when you have an intention an idea to present models, there is always a temptation, a tendency to making stereotypes. Models are stereotypes. You should not take them as dogmas. They express tendencies. I have identified these four models. Civil service model has been already mentioned. Basically, it means recruiting for the judiciary fresh law graduates. There is a second model called professional model, which consists of recruiting experienced legal professionals, for example, practicing lawyers or civil servants. There is now a tendency of mixing both, for example, in Netherlands, in Finland, to an extent in France, also in Spain, trying to combine the advantages of recruiting fresh law graduates with the necessary complement of a professional experience. And there is a model which I call political, which is a shared recruitment decision system between politicians and the judiciary. It applies mainly to higher courts, to constitutional courts, etc. It has been already mentioned. In the civil service model, we can observe several submodels. I mean, the recruitment of fresh graduates as such, coexisting with recruitment systems of more seasoned professionals, which represent several tracks to enter the judiciary. But still, the merit system, etc., remains to be an important element. The civil service model perhaps is best fit for countries aiming at creating independent judiciaries in relatively recent transitional situation. Is the system prevalent in continental Europe? The professional model originated in the Commonwealth countries of common law, while this civil service model originated basically in France and expanded to the whole continent. It has three basic features. One is merit-based recruitment, in which theoretical legal knowledge and qualifications of candidates are central, and is accompanied with a long induction training period, normally in judicial schools, judicial academies, and so on. Second is promotion to the ranks and scales based on seniority, and relatively recently has been introduced an evaluation of professional merits, especially continuous training and specialization, and to an extent the performance appraisal. Although I have to say that performance appraisal of individual judges is problematic and is still, to put it this way, is still an instrument of management of judges under construction, I would say. And three is employment in the judgeship is for life, is tenure for life, if not disciplinary or penal action occurs. So this will be the main feature, which, again, with a lot of variation, etc. Then we have just a small account of advantages and disadvantages of this model, which is prevalent in continental Europe. The advantage is a strong merit-based management component, even if the Ministry of Justice may have a sway in management, as it happens, for example, in Germany or in Austria or even in France. Impartiality is the most valued professional characteristic. The aim is to have judges who appreciate, who adhere to the principle of impartiality. And third is strong protection from political interference. One of the main aims of the system is to shield the judge from political interference and from other interference too, lobbies, etc., vested interest, and so on. The disadvantages are, and these disadvantages are giving way to reforms trying to reduce them. The legitimacy must be based on expertise. Social experience and economic understandings of legal situation is rather marginal. Now we have heard our French colleague presenting how the French system is evolving to a situation in which this economic understanding of legal situation, the complexity of the situation, the international context is factored in the recruitment of and the training of judges. Little empathy to socially sensitive situations. Again, this is a fact. This is a fact that in many countries, judiciaries are trying to overcome through the induction training and continuous training. For example, gender-based violence. This is becoming a important part of the training of the judges, where some years ago it was not at all part of the preoccupations in the education of judges. And third, strong attachment to excessive legal formalism. This is typical of the whole in all continental European countries, also in the former Soviet Union countries. The legal formalism was a sort of refuge for being secret, to take decisions without any fear of breaching the law. International standards for recruitment, they have found two. One is the United Nations resolution of the General Assembly on 29 November 55, in which the main attention is paid to judicial appointment should prevent procedures, should prevent judicial appointments for improper motives, which is a very broad standard. The recommendation of the Council of the Committee of Ministers of the Council of Europe of 2010 is more focused in the sense that it is to recruit based on objective criteria pre-established in law or in the decisions of the competent authority, and introduces the notion of merit. Merit is understood as qualification, skills, and capacity to adjudicate cases applying the law while respecting human dignity. Bearing all this in mind, the conclusion would be that in a situation like the Kazakhstan one, or others who are still in certain transition, as it was pointed out earlier, the civil service model would be more recommendable because it requires good academic background, stringent competitive examination, and long induction training. Merit-based selection procedures should be used, managed by independent non-political authorities, be it a high judicial council or others, through pre-established impartial and transparent procedures and the results of the selection should be challengeable before court, before the administration first and then before court. For imparting administrative and penal justice, it is necessary to seek independent-minded individuals able to control the legality of the government decisions, including politicians, police, and prosecutors. In this particular field of administrative and penal justice, the tensions are enormous for judges to follow instructions from what it was used to know as telephone justice, and you understand what I mean. The role of the Constitution bestows to the judiciary within the public governance system should inspire the profiling of judges, should inspire the professional duties, the knowledge required, and ethical competences. It is necessary to distinguish selection, which is a professional procedure by using human resources management techniques under the majority purview of the judiciary, from the formal act of appointment. The formal act of appointment in many countries is made by the President of the Republic, by the King in Council, by the King, or by certain other authorities, but this is only a formality. And what we can elicit from all the presentation we have heard so far is that the checking of legal knowledge, the prior experience, etc., is important, but at the same time, we should introduce evaluation of the know-how of candidates in their prospective role as a judge or magistrate who will be deciding on the life, the fortunes, and the well-being of his or her fellow citizens. I will stop here, and you will have our paper on recruitment of administrative judges, which is in the last stages of preparation. We will put at your disposal. Thank you very much, and thank you for attention.
Спасибо большое, господа Варзалашвили и Кордона. Благодарим вас. Высший продолжает по модернизации отбора и карьерного продвижения судей, в ходе которой активно применяется зарубежный международный опыт.
Creation and implementation of international experience and information provided by you related to appointment of judges would be a good tool and good aid in this process. Next, the floor is given to Mr. Asensio, and he will tell about selection of digital technologies, taking the Spain experience into consideration. Please, the floor is yours.
Thank you very much. Good morning. I don't know if you hear me. I hope yes. Well, I am going to talk about the application of digital technology in the selection of judges. Not the initial training of judges, but the selection of judges. Well, I am pleased to be able to participate in this roundtable on modern digital and HR technologies in the selection of candidates for judges, assessment of the work and promotion of judges on behalf of the General Council of the Spanish Judiciary. I would like to thank Mr. Donakov, Chairman of the High Council of the Republic of Kazakhstan, for the organization of this event, which has a great interest and absolute validity. If a few months ago, I had been asked about the possibility of adapting the selection process of Spanish judges to new technologies, I might have answered that it was not necessary. Let us bear in mind that in Spain, as in the vast majority of European countries, a small number of judges are appointed each year. So in normal situations, traditional procedures based on physical presence work well. But the situation changed dramatically from last March. Home confinement and movement restrictions motivated by the COVID-19 pandemic have led to a change of mindset. The new information and communication technologies have been introduced in the procedures for the selection of the administration staff. Yes? Yep. And even in the development of judicial proceedings. But while video conferencing and remote access systems have been widely applied in the development of judicial proceedings, and in particular in the hearings, the selection process for judges in Spain has remained unchanged. In Spain, the access to the judicial career occurs by passing 3 examinations: 1 multiple choice exam and 2 oral exams. By March, the multiple choice exam had already been performed and the first oral exam was ongoing. Given the speed with which the confinement measures had to be taken, the General Council of the Judiciary agreed to suspend the first oral exam, which was resumed in July. From July to date, the exams have been carried out without any problems, taking the necessary safety measures to prevent contagion. But the exams have been held again in person and no in online case. However, in the General Council of the Judiciary, we have discussed the possibility of adapting in the future the selection process of judges to new technologies. For example, it has been suggested that while the physical presence of the candidate judge is essential, the examiners may not be present. In this sense, it could be possible to establish a video conferencing system that could allow examiners to listen to the candidate judge from his office or even from his home. Keep in mind that examiners are judges, prosecutors, university professors, and other justice officials, and they do not always reside in Madrid, where oral examinations are held, but in other territories of Spain. This is one possibility, but there may be others. What is essential is that wherever option is chosen, the principles that the organic law of the judiciary, in accordance with the Spanish Constitution, require for the selection of the judicial staff must be respected. I'm talking about the principles of objectivity, equality, merit, capacity, and in this particular case, specifically the principle of publicity. The exams must be public, in person or in online form, but all the exams must be public in order to respect the impartiality of the members of the tribunal. Any reform is possible whenever these principles are respected. This is a sine qua non condition. New information and communication technologies have a lot to offer us, but we should to adapt these technologies to the above mentioned legal principles. In other words, new technologies must be at the service of citizens and never citizens at the service of new technologies. This is in relation with the selection process of judges. But please let me talk 1 minute, 2 minutes about the initial training of judges. In Spain, the competence in order to perform the initial training of judges is the Spanish Judicial School, the institution I represent here. In this case, we have adapt the programs to the pandemic situation. But not only the pandemic situation, we have considered that the new technologies tools are very important and are very useful in order to perform the programs. For example, a lot of activities that before we used to organize in person, now we are trying to adapt this activity to online format. With the online format, we allow a lot of people to participate in these activities. So, of course, if you need more information about the initial training programs of the Judicial School, which is an institution under the scope of the General Council of the Judiciary of Spain, I offer my help. Of course, you have my mail, you have my personal details to contact me if you need this information. I don't want to go any further in time. I reiterate my gratitude to the High Council of the Republic of Kazakhstan. Thank you very much for your attention. Хорошо.
Спасибо большое, господин Асенсио, за ваше столь...
Asensio, for very meaningful communication and speech. And I think my colleagues will approach you for further information. And now the floor is given to the judge of the Supreme Court judge, Mr. Zholdasbekov, who will share his experience of use of modern HR technologies in the operations of the higher court. Dear participants of the round table, I wish you to have successful work. And one of the indicators is the use of modern HR technologies in the operations of the High Judicial Council. And it's important not only for Kazakhstan, but for the world as a whole. And this is one of the foundation principles of the government. And the principal role is given to the human rights protection, and it is an important condition to the country development. At the same time, the fairness is defined by the judges, who must own high moral and professional competences. In Kazakhstan, the judicial system has a number of national programs and plans. Pursuant to the instructions made by the leader of the nation, we had 100 concrete steps plan being adopted, and that provides for criteria for selection of judges. And the head of our country, Mr. Tokayev, has stated that judicial system reform is one of the highest priorities, and he also instructed to engage highly qualified professionals into the taxation, intellectual property, corporate law, and public awareness. The country has the specially designated commission established, performing under the president's office. They are targeting the rule of law and consistency with international standards, and this is supported by the strategic documents till 2025. And owing to this results, currently the council is authorized to proceed with qualification exam, competitive selection for vacant position, establishment of resource pool for managerial positions, and review of disciplinary cases against judges. To enable successful implementation of this objective, so we have created working bodies. These are Qualification Commission, Competitive Selection Commission, Resource Pool Commission, Judicial Juroes, Expert Advisory Commission. Formation of these commissions allowed to engage variety of civil society and community representatives and various specialists. This enabled transparency of council's performance and its consistency with OSCE standards. I would like to elaborate more on the system for selection of candidates that is being modernized starting from 2018. The first area is the qualification exam for the position of judge. Citizens who are willing to become judge first needs to prove their professional eligibility. This is the legislation knowledge test using tickets and psychological testing. And by the way, psychological testing was earlier recommended. Now it is a mandatory step. So number one is psychological testing that is held by the psychologist using specially developed methodologies for judges, where the motivation of the candidates is reviewed, availability of moral qualities and features is also explored. And this is one of the basic stages. Number two, computer-based testing for legislation knowledge. This year we have also optimized this testing. Number three, case studies. And this year we have started automated computer-based system. And after completion of the test, the answers are automatically coded with identification number assigned without any personal details. Number four is essay that is reviewed and evaluated by the academia community. Taking into consideration coding of the answers, the members of the commissions do not know who they perform this evaluation against. And the composition of the commission includes HR management, academia, international experts, and many others. The chairman of the Qualification Commission is an independent representative of the legal community.
Given the pandemics, the meetings of the Qualification Commission were online, avoiding the personal contact between the candidates and commission. And candidates could be also sent to the lie detector test. And this lie detection was cancelled thanks to the recommendation of the Venice Commission. So the candidate who passed through these stages can participate in competitions for the judicial positions. And currently, in order to improve qualification exams, the measures are being taken first, reducing the term retesting from 6 months to 3, more practice-oriented tests and exams and cases, and also differentiated approach to testing for the experienced lawyers, and to answer questions on 8 instead of 11, 6 obligatory and 2 optional, and the questions themselves will be deeper. And optimization of the terms for qualification exams for prosecutors, lawyers, experienced legal profession specialists, 2 stages instead of 5. And the procedure of knowledge assessment does not become easier because they have to resolve cases in the legal fields that will become more complex too. The second area is the competitive selection for the judicial position. The competition could be attended by those who passed qualification exams the graduates of the Justice Academy under the Supreme Court and the judges who would like to move inside the system. In the past, competition consisted of 4 stages: acceptance of documents, review of documents to see whether they're meeting the requirements, sending the candidates to the meetings on the cooperation of the courts on the local level. And of those, 2 were just formal, legal ones. But since last year, we have the new multi-tier competition for judge selection. And after 2 years of reform, the competition consists now of these stages: acceptance of documents. And on this stage, they must get the conclusion from the council on the local level, which consists of the legal community, mass media, and retired judges, which make the review of candidates objective. Then also seeing whether the candidate meets the requirements. For instance, the age of 30 years, citizenship of Kazakhstan, 5 years of legal experience, and other indicators. Number 3, assessment of candidates by special software using digital criteria. On this stage, the computer system automatically ranks candidates on the basis of qualification exams results, scientific degree, legal profession experience, and other indicators. The integrated assessment by the competition commission. The commission assesses the candidates against criteria that could not be automated. For instance, characteristics of their job performance, no administrative offenses, quality of adjudication, judges' ethics, and other. Number 5, using additional instruments for evaluation. In 2019 and 20, this stage was improved, and this helped to build a system which takes into account the public opinion when selecting the judges. On the website of the council, on the regular basis, we post the list of candidates for the judges' positions, and the public can submit the opinion on each candidate. In 2019 and 20, we got more than 1,800 feedback opinions from the public. And also, we do monitoring of social media and mass media. In terms of the former law enforcement employees, we have additional checks through those services they worked in. And also, the council takes into account the complaints about the current judges participating in the competition in order to study the opinion of the legal community, lawyers. The lists of candidates are sent to the bar associations. And for the Supreme Court, the 360 degrees assessment is done, studying the feedback about this potential judge from the colleagues. So besides that, for the candidates to the Supreme Court judges, we do a performance assessment using the independent HR specialists. For instance, this year, when we're recruiting Supreme Court judges, for the first time, we used the technology that is called Assessment Center, which is the most relevant HR assessment in this case. Also, we arranged testing in order to see their skills of understanding the textual information and the level of their logical thinking. This kind of test was based on verbal and figure-based tasks and numerical tasks. And also, the council can do additional evaluation of judges, like studying the video recordings of their hearings, studying the judgments issued by the judges, testing them for the knowledge of legislation, their specialization. Number 6, interviewing the candidates. Like in the case of qualification exams, interviews were done in the online format. Number 7, after all the stages are passed, candidates are submitted to the competition commission consisting of judges, lawyers, professors of law, legal community, general prosecutor's office, and HR management specialists. Number 8, after the competition commission's opinion, the pool of candidates is drafted for the approval by the High Judicial Council. Then the voting is done to make a decision about judges' recruitment, and every stage results are posted at the website of the High Judicial Council. Strict requirements to potential judges add to the current judges, strict qualification exams, multi-tier competition based selection positively affected the system for judges recruitment. And now only those judges are appointed who are worthy, and the procedures have become open and transparent, keeping in mind the opinion of legal community and public in general. So currently, in order to improve the recruitment procedure, measures are taken to improve the attractiveness of the work in small and remotely located courts, use of public opinion when selecting the judges, fast procedures for the local courts judges selection without damage to the quality in terms of subsoil, intellectual property, corporate law. In order to improve the recruitment selection on the request of UNDP in Kazakhstan, Ernst & Young company developed the framework for judges' competences. This is the set of skills and personal qualities needed to perform the activities. It's basic requirements to the quality of people who would like to be judges. And this competence framework consists of 9 competences that will be gradually implemented until 2025. This will be the basic instrument for assessment. They were tested this year when selecting the judges for the Supreme Court. More detailed information about framework will be shared by the Ernst & Young employee. The HR tools that I mentioned are used to establish the talent pool for the judges' positions, and the talent pool candidates will be a priority when filling the judges' positions. Besides HR technologies implementation, we're digitalizing our activities, and currently every area of activity of the council is digitalized using IT technologies. 2 meetings of the Qualification Commission, interviews with 500 people during competitive selection have been done in the online format. Besides that, when studying the candidates during the competition, the automated system of assessment is used. The meeting of the panel that looked into 82 administrative cases were done electronically. 6 meetings of High Judicial Council were conducted in the online format. This year, we implemented the information system for the High Judicial Council on the accounting of the judges in order to digitalize the judgments, the cases. Main documents are there, like copies of IDs, diplomas, education, disciplinary reproachment, and so on and so forth. And this helps to improve the state of the judicial corps in the country. And we will implement the automated system to submit the documents and qualification exams for the judges and competitions that are online. So digital technologies will be leveraged in order to optimize the activities of the High Judicial Council. And we have to mention that with the participation of international experts from Canada and Georgia, external independent assessment of the High Judicial Council was done. Recommendations were made about qualification exams, competitive selection of judges, talent pool formation, and other recommendations. Dear participants of the forum, let me wrap up my presentation and let me say that the High Judicial Council, in pursuit of its policy, uses HR technologies that are digital. Now let me give the floor to the chairperson of the Higher Qualification Commission of Russian Federation, Mr. Timoshev Nikolai. He will tell us about the role of the Qualification Collegium of Russia in selection, promotion, assessment, and especially the work of the Qualification Collegium in the context of pandemic. Please, the floor is yours.
Уважаемые участники круглого стола,
Dear participants of the roundtable, dear ladies and gentlemen, let me welcome you on behalf of the Collegium of the Russian Federation. I participated just now in the case hearing online, and now I am participating in this online meeting. The position of a judge is one of the most important social factors in the administration of justice and constitutes its organizational basis. The specificity of the formation of the judiciary is determined by the special status of the judge. A key role in this multi-stage approach in the Russian Federation is assigned to the Qualification Collegium of Judges. The Qualification Collegia of Judges in Russia are the bodies of the judicial community endowed with the state powers, including the selection of applicants for the position of judges, promotion and qualification certification. Collegium and the judge interact, starting from the receipt of initial documents to recommend the candidates for the vacant position to the termination of powers, and later until the judge's resignation. The nature of activities of the Qualification Collegia of Judges determines the independence in decision-making from outside influence. This independence is ensured by the formation of Qualification Collegia in accordance with the European and international standards. They consist of judges of courts of different instances, constituting the majority of the Collegium, as well as representatives of the legal community and a representative of the President of Russia.
The pursuit of state policy aimed at improving the quality and efficiency of function of judicial system and strengthening of independence of the court leads to an increase in requirements for judges as carriers of judicial power, including the level of their professional training and personal qualities. According to the Russian Federation Constitution, judges can be citizens of our country, reached the age of 25, who have a higher legal education, at least at the specialist or master, and work experience in the legal profession for at least 5 years. In addition, requirements regarding the age and length of service are established by laws of judges, depending on the level of the court. A person who meets the requirements for candidates for the position of a judge has the right to apply to the examination commission to confirm his professional knowledge during qualification exam. It consists of two parts: theoretical part of the exam, where the applicant provides verbal answers to the question, and also examination cards on the task of judicial practice. In the practical part, it is required to demonstrate skills in drawing up a draft document for a specific case. Prerequisite for appointment to the position of judge would be positive conclusion of the judge collegium based on the results of competitive selection. The world experience indicates that it is competition that allows to enable selection of the most worthy candidates for the position of judge in a democratic way on the basis of equal opportunities for all citizens. The selection of applicants for the position of judge is the highest priority and large-scale area of our activity. The main thing here is the sufficiency of information, objectivity, impartiality. How are judges being selected in Russian Federation? The Qualification Collegium of Judges announces the opening of the vacant position in the print media and on the website. The terms for the announcement of vacancies are prescribed by the law. A citizen who has passed qualification exam and his results are valid for 3 years, or a judge applying for a higher position has the right to apply to the qualification collegium with an application for his recommendation for the vacant position of a judge and submitting a package of documents and information about him or herself and his or her close relatives. The qualification collegiums of judges arranges for verification of the accuracy and completeness of the documents, verifies characteristics from the previous places of work, conducts an interview, meeting of the collegium, and finally provides an opinion on the recommendation of the candidate for the position of judge or refusal to do so. In 2019, the qualification collegiums of judges of Russian Federation more than 8,000 applications for the position of judges of federal courts, and within 5 months of this year, it is more than 5,249 such applications. Collegiums carry out their sessions in a publicly available platform and widely covered by media. Qualification collegia of judges have a certain discretion in making decisions on the recommendation of the citizens for position of a judge, by virtue of which the absence of grounds established by the law for refusing a recommendation for the position of judge does not automatically entail a decision on such refusal. In the selection of judges, various methodologies are utilized, a whole range of taken into consideration, and these measures are approved by the High Qualification Collegium of Judges of Russian Federation and by a decree of the President of Russia. Various special information software are used which allows to check the reliability of information. For instance, property and income records, tax obligations, and this also allows to objectively assess the results of the professional activity of the judge. The analysis of the performance and quality and efficiency of the administration of justice is compared against similar average indicators of judges for the courts and courts of the corresponding level. The reasons for violation of procedural terms and the reasons for cancellation of the court decisions are also studied. And we also evaluate whether they do not impose an obstacle to the appointment of the applicant due to insufficient qualifications. Citizens expect from a judge not only to have the knowledge of the law, but also decency, honesty, thoughtfulness, objectivity, and incorruptibility. A judge should not be a person who has destructive qualities such as irresponsibility, self-interest, arrogance, lack of respect to others, unwillingness to maintain knowledge and authority at high level, and unwillingness to see his or her shortcomings. To clarify these circumstances, the qualifications judges offer the applicant to give written explanations on the fact of his or her biography. And it is important not only what the applicant will answer, but also how truthfully and honestly he will do it. Compliance with anti-corruption legislation, inclusive of procedures stipulated by procedural legislation to ensure impartiality and objectivity, is assessed. In order to improve the quality of competitive selection, additional methods of personality study of the candidate, HR tools have been developed and been applied. And one of them is a psychological examination of the candidate, the methodology of which was developed by the Judicial Department. It takes place in practice of the Qualification Collegium of Judges. It is carried out in compliance with the principle of voluntariness, scientific character, objectivity, and confidentiality. There is also practice when the applicant who has passed the qualification exam but has no experience is recommended to undergo internship. The main objective of the internship is to study the specific of judge's work and acquire necessary practical skills. Feedback on the internship is submitted by the applicant to the qualification board. Thus, the decision to recommend a particular citizen for the position of a judge is based, first of all, on an individual assessment of both professional qualities of the applicant and data on his personality, including moral and ethical attitudes. The results of reviewing the applications are posted on the website of the Qualification Collegium of Judges. The texts of the conclusions are also posted there. They are available to public. In a pandemic environment, we all had to adapt to new realities and take a fresh look at our capacities. Back in June 2019, in the regulations on the procedure for the work of Qualification Collegium of Judges, a rule was prescribed on the review of materials in the meetings by using remote access systems. From February to September 2020, using this technologies, the Higher Qualification Collegium of Judges reviewed more than 40% of applications for the positions of judges. Online participation is available not only for applicants, but also for the members of Qualification Collegium and other persons participating in the meeting. Holding the meetings in such a mode allowed us not to suspend our activities during pandemic and make our work just as effective as before. The quality of review of materials and decision making was not compromised due to a deeper probability of each issue. In addition, time and financial costs have been reduced. Therefore, we will continue this practice and extend our experience to regional collegia. The newly appointed judge is undergoing professional retraining. Further professional development and training of judges is carried out as needed, but every 3 years. A specially established higher educational institution, the Russian State University of Justice, is a professional platform for retraining of judges and advanced professional training. The main method for the results of judicial activity is qualification certification of the judge. All judges undergo certification Qualification Collegium. The judge has no right to refuse to pass it. This area is significant in terms of volume and significant in content. In average, about 10,000 judges of the country undergo qualification certification annually. Qualification classes are assigned to judges depending on the position held, length of service, and circumstances provided by the law. The assignment of the class does not mean a change in the status of the judge relative to other judges. There is a concept of a marginal qualification class depending on the level of the court where the judge works. Above this limit, qualification class cannot be awarded. However, a judge is required to undergo certification every 3 years. The established system of qualification classes allows us to talk about the formation of a system of professional growth for a judge. This aspect is important for the effective function of the judicial system. In conclusion, I would like to note that formation of a judiciary that meets the criteria for high quality and prompt administration of justice is one of the priority areas of work of the bodies of judicial community. With all of the variety of procedures and technologies used in the selection of candidates, the accumulated experience of various states has one thing in common: the desire to empower the most professionally trained and highly moral candidates with judicial powers. Improvement of the procedures for appointment and promotion should contribute to the development of professionalism based on an objective assessment of the results of their performance. We are interested to gain the experience of other countries in these areas. Such work, in my opinion, can and should be carried out with participation of the entire legal community, both practitioners and theorists. Thank you for your attention. Take care of yourself and your loved ones during these difficult times of pandemic. Thank you very much, Nikolai Yuryevich, for your interesting and very meaningful report dedicated to the rich Russian experience. We hope to have a close cooperation with the Qualification Collegium of Russian Federation, and we wish you to have successful outcomes. And thank you very much. Next, the floor is given to the chairman of the High Judicial Council, Mr. the chairman of the Judicial Council of Uzbekistan, and he will share Uzbekistan experience using digital technologies. Mr. Hamamin, please, the floor is yours. Good afternoon, dear participants of today's event. Let me welcome you on behalf of the High Judicial Council of the Republic of Uzbekistan. My name is Isakov Khojmurod, and I'm the deputy chairman. Our chairman is very sorry, but unfortunately he cannot make it with the report. But I would like to inform you that pursuant to the relevant decree of the president in our country, we are passing through the preparatory stage for reformation of courts. And in parallel with our roundtable, there is an outstanding non-scheduled meeting our chairman has to participate. The agenda being discussed today is very much relevant, and I hope that the outcomes will be very productive, because implementation of digital technology during selection of candidates would be fundamental for further establishment of a judicial pool. And I would like to say that the report of Mr. Zholdasbekov regarding the Kazakhstan's experience of technologies implementation was very useful for us. And also, I would like to touch upon reports of Mr. Paplashvili and Venice Commission representative were very interesting. So if you would allow me, let me elaborate more on the High Judicial Council of the Republic of Kazakhstan as related to the selection, evaluation, and promotion of judges in the Republic of Kazakhstan. The High Judicial Council of the Republic of Kazakhstan is developing electronic and software solution for selection and promotion of judges using specific criteria and indicators. Currently, these criteria are prescribed by the specific provision, and pursuant to this provision, within 5 days, the record shall be submitted by the judge and by the independent representative, and based on the results, the commission puts its evaluation according to the score for each criteria.
And the decision of the qualification commission is based on the average score. The current assessment system has got the following drawbacks. The evaluation is done on the basis of the opinion signed by the judge, him or herself, and also there is no assessment of each and every criteria. And all the assessment criteria are based on the human factor. And therefore, the High Judicial Council is implementing the electronic system that would allow to assess the performance of judges by the following 8 key professional areas. And also it helps to integrate this course in the electronic software. First, the judge should have a wide world outlook and be a professional who has got the capacity to ensure rule of law. And also the judge should be impartial in interpreting the law. In terms of discipline, the judge has to strictly follow the deadlines established by law. Number 4, the efficient judge should be efficient in the performance and be highly productive. Good behavior. The judge must follow the law, public order, and ethics of the judge. Responsibility. The judge should be very responsible about his or her activities and must really believe that people's fate and life depend on the judge. And the judge, being a qualified lawyer, has to adjudicate reasonably and word it properly. And the judge must be capable of using state-of-the-art independent ICT technology. And also, the scoring system is used to minimize the human factor in order to create a good pool of judges and ensure better access to justice. Also, we have to mention that in the past, the recruitment and selection of judges was decided behind closed doors. It was an exam which was verbal, based on Q&A, but now this is done using ICT technologies. In this case, the candidate has to choose one of the tickets on the computer screen and respond to the question posed. Other candidates and public can observe the process in the online mode in the waiting room and also at interactive tools of the High Judicial Council. In 2020, we are planning to create the club of judges at the level of High Judicial Council in penal law, economic law, but also the club of women judges. And the objective of the club of judges is to improve the coherence in the judicial and establish a platform for judges' communication with each other in order to seek advice on challenging cases and to achieve the uniform legal judicial practice. And also one of the mechanisms for the judges selection is based on the creation, development, and delivery of the psychological test in order to see whether the candidate is compatible with the position offered. So it would be very good to hear from the participants about their experience in this regard. Having this opportunity and seeing the representatives of UNDP at this round table, let me extend my gratitude to the UNDP because the question on development and implementation of the psychological test to see whether the person is psychologically compatible for the position has been done together with the UNDP in Uzbekistan. I'm sure that this roundtable will be a starting point for deeper collaboration between the judicial systems of the countries' participants. And I thank all the organizers and participants of the online meeting. Thank you for your attention. Thank you so much, Mr. Hajimurat. We are happy to see you all. We have met last year. It was a face-to-face meeting. Today we have this online meeting. Thank you very much for your presentation, which is very informative. And I hope for further collaboration with our Uzbek colleagues and brothers. Your experience is very interesting to us. And we really wish you success and to stay in good health. Now I would like to give the floor to the judge of the Supreme Court of Kazakhstan, Secretary of the Commission on the Quality of Justice under the Supreme Court, Mr. Tisenova, who will talk about the system of professional evaluation of judges in Kazakhstan. Hello, dear participants of the roundtable. In order to implement the task given by Hilbasi and President of the country on enhancing the responsibility of judges and assess their professional activities, amendments were made to the constitutional law in 2019 about the judicial system and status of judges. The judicial jury, with the functions of considering disciplinary cases, has been transferred to the Supreme Judicial Council, and a commission on the quality of justice has been created under the Supreme Court to assess the professional activities of judges, confirm the judges' right to resign, and terminate the authorities. In April 2019, the order of the President approved the statute of the commission, and the composition was chosen. The assessment of the professional activity of a judge was carried out earlier after first 5 years for higher position. And we abandoned the old system, which is based on the tickets, as we studied international experience. According to the Venice Commission, a regular assessment of the judges' performance is an important tool to improve their performance and can serve as a basis for promotion. The standards of the Consultative Council for European Judges prescribe the mandatory presence of quantitative and qualitative indicators in the assessment system. According to the OSCE, the assessment of the judges' professional performance should be of a qualitative nature, with the emphasis on judicial skills, professional competence, and leadership qualities. Under various names, the assessment is present in the laws of most countries of the world. According to the Article 31 of the constitutional law, the assessment of the professional activity of a judge is carried out for the first time after 1 year, and periodically after the expiry of subsequent period of 5 years of continuous tenure of the judge from the date of the previous assessment, and if they participate in competition for the position of a higher instant judge, chairperson of a court and chairperson of the judicial board. Judges with more than 20 or more years of judicial experience are not assessed. Taking into account the task set, the Commission radically revised the system of professional activities assessment of judges and adopted a new assessment methodology, which is based on transparency, objectivity, and fairness of criteria implemented from the best international practices. The advantages of our new methodology are presence of transparent and objective criteria in contrast to the old methodology, which was based on tickets and bare numbers. The methodology comprehensively uses a wide range of qualitative and quantitative methods for data collection on the judge's performance. Minimization of the human factor, full use of information technologies, creation of electronic statistical module on their basis. Then, time savings of judges. The Supreme Court, only judges who have not reached the threshold level of points according to the main criteria for the Supreme Court to pass additional assessment tools. The rest can be informed by the results of assessment and points received via video conferencing. According to the requirements of the constitutional law, the assessment of the professional activity is carried out with participation in competition. The professional activity of a judge is assessed by judges only. The evaluation for participation in the competition is based on the same criteria as for the periodic evaluation: professional knowledge and ability to apply them in the administration of justice, results of judicial activities, business qualities, moral qualities, compliance with the requirements of the Code of Judicial Ethics. Each criteria group consists of sub-criteria. Almost all data is downloaded directly from the information systems of the Supreme Court. For this, a special statistical data module has been created. Professional knowledge and ability to apply them in the administration of justice. This criterion is the criterion of professional knowledge of the judge, and ability to apply it in the competition, which is calculated on the basis of a number of cancelled and amended adjudications. This data is downloaded from the statistics model. The number of cancelled or amended judicial acts is not the evidence or sufficient basis to make conclusions about competences of the judge. That's why the reasons of the cancellation and amendments of judicial adjudications are subject to study. The reasons for cancellations and amendments are assessed by Commission on the basis of their materiality and according to procedural legislation. Then the judicial results as a group of criteria makes it possible to determine the effectiveness of administration of justice by a judge. It's based on objective data, on the criteria of judicial workload, compliance with procedures, deadlines for the relevant period. And the period is not more than 3 years when they study the professional activities according to the specialization in comparison with the average workload in the court for the same period in the relevant specialization. In civil cases, the number of decisions. In criminal cases, the number of sentences. For administrative, the number of decisions. The third criterion is assessment of business qualities. Assessment of business qualities of a judge is based on the results of annual confidential survey of the court staff, management, judges, court employees to identify the level of business communication skills in the team. This criterion allows to determine interpersonal qualities, respectful behavior of chairperson and judges in the team in relation to other judges and court employees. To identify the leadership, managerial, and communication skills of judges participating in the competition for the position of the chairperson of the court and chairperson of the judicial collegium, interviews are conducted with the members of the commission. The purpose of the interview is to determine whether the judge has got business quality to work as a head of court or judicial board. Moral qualities, assessment of moral qualities for compliance with the codes of judicial ethics requirements is done according to the following criteria. First, compliance with the judicial ethics, presence and content of complaints against the judge's action. This criterion makes it possible to determine to what extent the behavior of a judge, both in adjudication and in any actions, social activities, and everyday life correspond to the high status of the judge's position. After the completion of the process of assessing the professional activities of the judge that participates in the competition for the judge of higher instance, chairperson of the court or collegium, the marks for each criterion are entered into the summary table where the final weighted mark is calculated. The final weighted score is calculated on the basis of specific weight for each group of criteria.
To determine the level of professionalism of judges participating in the competition, the following scoring is applied: A, excellent level, C, sufficient, D, unsatisfactory level of professionalism. The distribution of the professionalism by level is carried out on the basis of the generally accepted 100 score or percentage assessment system for judges, chairman, or presidents of judicial collegium. Based on the results of a comprehensive assessment of professional activity, the commission of the following decision: recommend for appointment or refuse to give recommendations. The recommendations can be appealed by the High Judicial Council. Taking the experience and methodological guides into account, the assessment is performed to improve the quality, improve professional qualifications, upgrade responsibility when considering cases. Last year's and current year's experience indicates that there are positive aspects in the training of judges which somehow facilitates the work of the commission. Evaluating the work of colleagues and making decisions, especially those negative, is not easy. This is not only a physical but also a very great moral burden. Currently, the Commission continues its work in compliance with the principles of transparency and fairness in accordance with the approved regulation and assessment methodology. Thank you for attention. Thank you very much, Ms. Nuria, for your meaningful report, and we wish you success. Next, the floor is given to the Kyrgyz Republic Selection Council, and they will share the use of modern technologies during selection of the candidates in Kyrgyz Republic. Mr. Guljana. Good afternoon, dear members and dear chairman. My name is Koshokova Gulzhan Jarmatovna, and I'm the member of the board for judge selection in Kyrgyz Republic. Due to technical reasons, I participate from the account of Nazira Sopubekova. Dear participants of the conference, the agenda of our report is the use of modern technologies during selection of candidates for the position of judge in Kyrgyz Republic. First, I would like to elaborate on the performance of our council. The Selection Council is the constitutional body whose main objective is to fulfill the constitutional provisions as related to the establishment of judicial bodies in the Kyrgyz Republic. Pursuant to the law on the Judge Selection Council that was adopted in 2017, the council is composed from 9 members that are approved by the resolution by Zhegor Kukinesha, and the composition is drafted the following way. 1/3 is the other judges selected by the council, and this is one of the highest bodies for self-management. Also, 1/3 is selected by the civil community, by the votes, and 3 is the opposition of Zhegor Kukinesha of Kyrgyz Republic. The range of the term for competences is 3 years. According to the Article 5 of the Judge Selection Law, the composition is defined using the following principle: not more than 70% of people of the same gender, meaning that we are consistent with the gender equity principle that is, in addition, is stipulated by the law. The composition of the council currently has 6 male and 3 female individuals. The existing composition was selected by Zhegor Kukinesha in 2017. It is our activities are regulated by the Constitution of Kyrgyz Republic, by the constitutional law on the status of the judges in Kyrgyz Republic law on the Judge Selection Council, provisions for competitive selection of the candidates for the position of judge in Kyrgyz Republic, and regulation for the Judge Selection Council. Since the topic of my report is the use of modern technologies during selection of the candidates, let me touch upon the procedure for use of modern technologies. Let me start that all of our activities within our council are publicly available, transparent, and starting from the competition announcement, all stages of competitive selection are published in the media and on the website of our council. After the announcement, the detailed information is placed on the website, specifying the procedure for obtaining the applications, criteria for the vacant position, topics for written task and topics for verbal ones, and the applicants can have a general picture of the requirements and the scope of knowledge that they are supposed to demonstrate during the competition. Further on, after review of the documents, all of the stages of our competition are also recorded with the video and audio recording of all meetings of the council. During such meetings, and interviews. The observer has to witness which is majorly represented community, and our independent observers. Video and audio recording outside of the building are broadcasted, and anyone volunteering to participate may attend and listen to the competition session. If we give attention to the stages of the competition, the first stage after the desktop review and admission of the applicants to the competition would be computer-based testing. And this testing is automated and in fact represents the system that is attributive of minimum human interface. This is in fact a list of questions that is provided to the candidates for computer-based testing. Access to this system is not provided to the Judge Selection Council members. The questions themselves are drafted by and approved by the Council of Judges of Republic of Kyrgyzstan, and the system is maintained by the special institution. The computer database consists of 1,000 questions in 10 fields of the law. During the test, each of the candidates receives a randomly selected 100 questions, and 1 hour and 40 minutes is given for the entire set of questions, which means a minute for one question. When timing is over, the system terminates the session, and immediately the results are being printed out. And at the same time, as I have already mentioned, the members of the council do not have access neither to the questions nor to the test in itself. It is just a procedural wise participation of the council. We just witness. We do not physically witness the testing, but we provide the results to the applicants, and if successful, we admit the candidate for the next stage. Computer-based program is set up such a way that upon finalization of the computer-based testing, there is an opportunity to get familiar with the performance of the candidate, with the number of right and wrong answers. We have marginal scoring established. Out of 180 questions, 100 has to be answered correctly to be admitted to the next stage. Relevant certificate is issued that is valid for 2 years. After moving to the next stage, the candidate, and by the way, next stage is the written assignment. The candidate is invited to the interview, and the first stage is written task, as I have said, which is represented by which is not represented by computer-based technologies. The candidate is given specific case with the simulated situation. For instance, some claim or some other scenario that has to be provided with the conclusion and opinion. And the third stage is an interview, which aims to identify professional and moral features of the candidates. And during the interview, we have a specific criteria with attached questions, and this criteria is preliminarily approved by the Judge Council, and the list of questions is also approved. And each member of the council provides their scoring to the candidate in the computer, and each of the judges provides a score, and information is routed to servers, and the server calculates final interim score, and the system provides it back to the decision makers. The council members do not have access to this scoring calculation system, and during such voting, the candidate stays in the room, information is collected, summed, printed, and the candidate is provided with the state of his or her features. The entire procedure, as I have already mentioned, is performed with the video and audio recording that are stored not only at the server of the council, but also in the Adalet Sot authority. And this Adalet Sot authority is the agency responsible for digitalization of the entire judicial system in Kyrgyz Republic. Thank you for attention, dear participants. And once again, let me communicate my gratitude to the facilitators of this roundtable and opportunity to talk. For Judge Selection Council of Kyrgyz Republic, it is critical to have an opportunity and study the experience of other countries as related to the selection of the judges. Thank you for your attention. Thank you, Ms. Guljan Jarmatovna, for sharing your experience and your interesting expertise. We wish you success. And now the floor is given to the Director of the Training Center of Judges under the Supreme Court of Tajikistan, Mr. Saleh Zavkizoda, and he will share Tajikistan's experience in application of modern technologies in the process of selection and training of judges and candidates for judicial positions.
Dear Mr. Danakov, dear colleagues, participants of the online roundtable, first of all, let me thank the High Judicial Council of Kazakhstan for inviting me to participate in the work of the roundtable to talk about these relevant topics. And let me discuss the issues that we are facing. And let me also extend my gratitude to our partners, representatives of the UNDP, for your continuous support and cooperation. And of course, work is much needed in order to ensure transparency, impartiality, and integrity, which are paramount for the protection of rights and legal interests of the participants of the court cases. The law on course in Tajikistan and provisions on the Commission on judges' evaluation and other regulatory acts include the procedures for the judge selection. The independent judicial system is very much needed to ensure the rule of law and adjudication and the selection of judges is one of the integral parts and the necessary condition for the independence of the judicial power. The founder of National Accord, President of Tajikistan, pays special attention to the judicial system. At the meeting with the judicial employees on the 25th of November 2019, he mentioned that the challenges of current time really mandate the impartiality, integrity, ethics, justice, honesty be a basis and key criteria of the personality of every judge. Selection of judges in Tajikistan is the competence of the Supreme Court of Tajikistan, and the process of training of the new candidates, intern judges, and this is the competence of the training center under the Supreme Court, which is a specialized body in the field of judicial education. In terms of judges selection, it's based on the competition. Competition is announced in mass media and on the website of the Supreme Court of Tajikistan. The candidates who were examined, who are checked and verified, they can pass the exam, consisting of the exam on the national language and exam on all the areas of law. The exams are made by the commission that decides about the judges, intern judges, and it consists of representatives of different agencies, the Center of National Legislation, and the Tajik State National University. This commission was created in 2017 by the decree of the President of Tajikistan. The exams procedure is covered by the mass media, and after the successful examination, the examination commission submits the list of candidates for judges positions who are then trained in the training center, and they also have internship in the lower instances judges, and this is included as into their professional work experience. And after the positive opinion of the qualification collegium, upon the recommendation of the judges community, and upon the approval by the chairperson of the Supreme Court, High Economic Court of Tajikistan, the candidates for the judges' positions are submitted to the president for formal appointment. And speaking of the current judges already working as judges, they have to be assessed by the qualification collegium, where their practical knowledge is assessed, their performance, and their morale. The members of the qualification commission, which is 9 judges, are selected by the Judges Association by anonymous or open vote. The opinion, especially the positive opinion, of the qualification that lists the candidates is to be enforced. And of course, it's important to select judges with the use of new technologies. In the process, in the context of pandemic, the technological priorities have shifted and digitalization has penetrated all areas of organizational activities and have become its natural process. And in Tajikistan, this is something that we focus a lot on, and we do certain changes in the organizations of our country, including judicial, like courts, in order to arrange teleworking and remote educational cases. As we know, the Republic of Tajikistan is modernizing its High Judicial Council, and Kazakhstan has got this practice. So Kazakhstan focuses a lot on upgrading the system of selection, and these practices are very interesting and beneficial for the Tajikistani colleagues. And we have to mention that many countries use the new technologies and processes to implement the state-of-the-art experience that has proven to be efficient and effective when selecting the judges and promoting the judges. The Republic of Kazakhstan and really is a leader in CIS in terms of the application of new technologies. On the backdrop of the COVID-19 pandemic, we are seeing that new technologies have to be implemented, cutting-edge technologies, when selecting the candidates for the judges' positions and when assessing their performance. And we have to say that this year, as part of our cooperation with international organizations, we have delivered joint events to train and improve qualification of judges using online technologies to reduce the negative impact of COVID pandemic on the judicial. We are working with the development partners, especially with the UNDP in Tajikistan, to study new technologies for staff selection. And next year, we are planning some activities to assess the performance of judges in Tajikistan, to draft the strategy for judicial development until 2030, but also to study the advanced experience and application of new technologies and HR technologies when preparing and training the future judges. In order to implement such a program, we need to train the specialists, to train them in application of digital technologies, to look for the most optimal model, which is important for assessment and training of judges. And we would like to study the practice in Kazakhstan, like practice of the High Judicial Council, as well as other countries' experience, how they use digital and information technologies that facilitate the improvement of quality when selecting judges. And the roundtable that is being held today facilitates the exchange of experience and development of sound proposals to improve the judicial systems of the countries, and really brings very tangible results. Let me thank the organizers of this roundtable and wish you all to stay in good health, great successes in your work, and I thank you for your attention. Dear Mr. Zavkizada, thank you for your informative presentation, very useful. We are ready to continue cooperation with our Tajik colleagues and friends. We wish you success and good health. Now let me give the floor to the Senior Manager, Head of the HR Services Group at the international company Ernst & Young in Kazakhstan, Mr. Nikolai Khan, and who will share the information about the framework that was specially developed to satisfy our request. Please, Mr. Khan, the floor is yours. Dear Mr. Danakov, dear guests of the round table, I'm happy to welcome you. Thank you for inviting me to speak. My name is Nikolai Khan, and I'm the Senior Manager of the EY company, Head of HR Consulting Services in the field of HR management. As you know, EY company is an active participant of projects to reform the government agencies, including those in the Republic of Kazakhstan. And last year, we started our project in 2019, finished in 2020. We were honored to provide support to the High Judicial Council of Kazakhstan in implementing the project on the framework competences for the judicial system of the Republic of Kazakhstan. Let me share with you how this project was implemented, what work has been done, and let me inform you about the outputs. What is the framework competence model developed? Speaking of the project, its main objective was to develop the competence model for the Republic of Kazakhstan. This is the uniform framework to improve the efficiency and effectiveness of the training process, selection, and promotion and development. In order to fulfill this task, first we analyze the current system of the competence assessment and current system for the selection and competitive assessment of judges in the judicial system of Kazakhstan. Further down the road, we analyzed the international experience of the competence model. I will talk about it in more detail next slide. We conducted interviews, focus groups, surveys of the judicial system and the legal community to get their feedback, and we developed the competence assessment tools that were given to the High Judicial Councils after the project. And that speaking of the international experience, we studied the experience of 9 countries, European countries.
And we have explored the experience and competences model in Austria, Albania, Great Britain, Germany, Ukraine, Mongolia, and Belgium. Part of these countries, such as Austria, Belgium, UK, Germany, and France, were selected based on the principle that they have a high level of judicial system development according to the rule of law index. And 3 countries, such as Albania, Ukraine, and Moldova, were selected on the principle that recently they have completed the judicial system reforms, and this is why we have included them. First of all, we have explored the competences model, the competences that are used by the countries, and how the assessment system is arranged, what are the gaps, and how we can use and leverage the outcomes of such assessment. Further down the road, we have, after the examination of the international experience, we have held number of interviews with the judges of Supreme, province, or cities, and other courts. And the objective of this interview was to analyze the performance of judges of various levels and identify required managerial and personal competences. Based on this interview and international overview and taking our expertise into account, we have compiled the long list of competences composed of 23 competences, and which we continue to refine. And we have shortlisted it. Then we have held 4 focus groups engaging existing judges. 1 focus group in South Kazakhstan in the city of Shymkent, 1 in West Kazakhstan in the city of Uralsk, 1 in North Kazakhstan, city of Petropavlovsk, and East Kazakhstan in the city of Uсть-Kamenogorsk. The focus groups were held with the effective judges of Oblast courts, and then we also held online questionnaire amongst legal people, legal consultants, attorneys, to identify the criticality and importance of specific competences. So we have provided them with a long list of competences, and we suggested them to rank them against the importance and criticality for the judge activities. Then we have developed the competences model that is currently composed of 9 competences, which 5 of them are corporate competences that relate to all employees, and 4 managerial competences that are important and needed to the managerial level of employees. And let me elaborate more on what we have included into the framework of competences. These are corporate competences that are general for everyone. This is decision-making, efficient communication, systemic thinking, self-development, and planning. What do we mean by decision-making? First of all, this is an ability to take the decision based on the facts, taking the responsibility for the decisions being taken, and ability to find and take decisions in the uncertainties environment or high emotional stress environment, which is an evidence of efficient judge. Next one is efficient communication, which is in fact an ability to communicate verbally, written, in the written form, and provide valid arguments to the message. And we have also assessed the format and the style of communication depending on the situation and the audience. Next one is the systemic thinking. By systemic thinking, we meant the ability to prioritize and split significant and important information from that not valuable, and ability to provide the logical conclusions. Self-development is the competence that evaluates and tells about the judge's intention to improve his or her professional development. First, we check whether the judge is open to the new experience, new knowledge, whether the judge is open to track the changes within the professional field and ability to change, in fact. And it is important to mention motivation for the self-development, whether the judge is ready and interested and understands that self-changes is an ongoing process, is a continuous process, and we cannot avoid such process if we want to have a professional growth, irrespective of the place of work. And the next competences within the corporate competences is the planning. To what extent the judge distributes the resources under his authority, ability to plan personal work scopes and those of subordinates. Next 4 competences are pursuing the evaluation of judges who have some level of managerial function. This motivation of employees, development of employees, arrangement of employees' work processes, and change management. And here we understand the motivation and engagement of employees into the work. So it's not only it's not an administrative tool and trigger that is used, but modern managerial technologies. Next one is the development of employees, and here we meant the extent the manager understands his or her role in the development of his or her employees, and to what extent this judge is ready to share his or her experience, act as a mentor, and provide assistance in development of the employees. The next competences is the arrangement and organization of the employees' work processes. And here we meant the way the manager puts the objective, the way he controls it, and the way he accepts it. And the last but not the least is the change management. And here it is important for us to check how the judge initiates the changes and how he or she implements them. What does he or she do to overcome the resistance of employees during the environment of changes? And also we have developed the set of tools. And this set of tools was referenced in Mr. Zholdasbekov's report. We have developed this tool for assessment of judge competences, and it was already successfully trialed. We have developed interview guide that is helpful during the interview sessions, and we have developed the questionnaire to have a 360 degrees evaluation of the judge. In addition to this, to have more comprehensive assessment, the judges recommended and communicated the metrics for performance and competences assessment. And let me elaborate a little bit more that this matrix is used to have better understanding of the capacity of a certain judge. And you can see the cross functions, and you can see the interrelation of the performance and competences. And it can be a gold high pot pool, high potential pool. It can be just a resource pool, or it can be some group of weight long-term efforts, meaning that it is the medium level of performance that requires some additional measures taken. Colleagues, this is all from my side. Thank you for attention. If you have any questions, I am available to answer them during Q&A. Thank you very much, Nikolai, for a very informative report. We hope that the unified competences framework developed by you will allow us to efficiently assess the candidates for the position of judge. And now the floor is given to the expert in the HR technologies, the member of the Qualification Commission, the Supreme Judicial Council of the Republic of Kazakhstan, Mr. Shikov Vladimir. The topic competences are important but not sufficient. What and how should be assessed for the selection of judges? So this is a dynamic discussion, and I think it's going to be very interesting one. So the floor is yours, Mr. Vladimir. Thank you very much. I will be very brief. I am supportive of every statement communicated by my colleagues, and I have nothing to add to this, but just some remarks. And to some extent, it is a very relevant topic for discussion. We all know that Kazakhstan has a hyper to enter top 30 of the world, and I have to maybe mention the company that I represent. Maybe not everyone knows what Samruk-Kazyna is. Samruk-Kazyna has 12 industry sector that is represented by the national company, each of them. Similarly to the Russian Federation, for instance, Gazprom in Russia, we have Kazgaz. And In fact, we have integrated all of these national companies into the holding, and corporate university is existent under the holding, and this is what the agency I represent. So how to reach this ambitious goal of being in top by 2050? So we're all human beings, all of us, judges that are being selected and assessed, and our life is always a swing, right? And sometimes we have a situation when we believe the world was created for us because it's a beautiful situation. It's a very bright, very many opportunities are available. But sometimes there are situations when we believe that we are in a total darkness. We don't believe in mankind, and it's such a difficult decisions that we have to take, but we are not able to. And this is the situation where Nikolai was referring to, that in fact, the stressful situation can be very bad time, but it can be very great joy that is also a stressful situation. Well, in some situation makes us happy, some situations makes us disappointed, and the very same is applied to work and home. These are the environment where we demonstrate our typical behavior, and our typical behavior is in fact a competency. We have around 40 competences existent within the nature, and we have some order for such competences, because any organization needs not only the performance and the result, but also they need to understand ongoing efforts. So when we take the decision, this is where we demonstrate our values, because in typical situations we basically do not go for our values, we just follow our skills. But in critical situations, irrespective of whether the person wants or doesn't want, all of the values that were grown by parents, by the community, they will reveal, because we are the carriers of these values. How all of this is interrelated. When we talk about the competences and behavior, they are definitely the reflection of the internal values of a human. We have basic cornerstone values, and there are not many of those. Everyone who has children knows that when the child is very small, when it's an infant, there is a character that he or she demonstrates. And in addition to this, we add with the established values, and by the age of 4 or 5, no, it's never a final personality, but the basic, the fundamental is already there during this age.
At 12, the key intellectual properties are determined. So a person has got chances to be a human by the age of 4 or 5. And by 12, they have chances to be clever. And this should be considered when promoting a person, because sometimes a person has got lots of capabilities, lots of desires, intellectual capabilities, but the values are different. How much damage could be caused by a person who in standard situation can demonstrate expected situation, but in a critical situation, he or she will behave according to the intrinsic values. And if we don't know those, we are in the risk situation. I found in the internet the code of judge approved in 2016 that shows a direct correlation between the expectations to the judicial to the strategy 2030-2050. If we want our economy to grow, there should be a legal field for that. And this 25 countries who so actually Kazakhstan wants to be top 5, but 25 countries we are talking about, these are the economies we know of. These countries miss some things. For instance, they don't have the dual interpretation of the law. Private property is protected by constitution and laws, and so on and so forth. And what is written in the code, in the judge's code, that we have to gain the trust of the citizens. And also, we must have the image of the judicial system in the matters of morale, integrity, and honesty. It's very important because investors and public at large should believe that Kazakhstan is the country where the investments should go. How can we get that? I'm not claiming that I'm the only truth. I'm just sharing the approach that we have found empirically in Samruk Casino Group. In the past, we used to assess competences at all levels. CEO of portfolio companies, first executives of national companies, members of the management board. But then we realized that our interviews based on competence doesn't work for high positions. I'll give you an example. It was the year 2016 when we had to assess the board members of one of the national companies, and we realized that what we have found in the interview is not in line with the reality. The question is how we did it. We did it according to a certain procedure, and the customer said, but it's not true. The customers of the village said that it's not the reality. That's why we realized that for the people who are very competent, the HR company's approach doesn't work because people who have high competences in their work track, they have got a lot of successful cases to showcase. So we realized that it doesn't work for the top management. Today we do interviews, but interviews is about motives. We look at the honesty behind the decisions for himself and the company, and we look not at the motivation, but we rather look at the motive to come. What drives the person? Why he or she is coming to us? Have a look at the slide. If we would like to implement the strategy, if we want to gain the trust to the judicial system for the people to be confident in us, then the judges at their levels on a regular basis, they find a situation. This could be a situation related to judicial hearings. It could be a decision on staff or decision on the collaboration with the judge or the chairperson, but they make decisions in their everyday life on their own level. So if we do not know the values that they live, if we haven't determined their value range that must underlie the decisions, then we will have a mess. People will make decisions in their competences, which could be drastically different. One person would believe we should go here and make this decision, but the other person would believe it's the vice versa. That's why we need to describe the values so that we, in our zones of competence, would make decisions in one direction. So if you don't know what to do, look at the values and make a decision. When the decision is made, it has to be fulfilled. It's a competence model. So what are we measuring? We are measuring the values that the person has in line with our values, and it's quite simple. If you recall the nature of recruitment and dismissal and you do the statistics, you will see that we took people because of competences and experience, but we fired them because of behavior and the decisions made. And this is about values and competences. That's why values and competences are very important. If the person knows the system we are building, they will make decisions in our direction, and they will be the example for the other judges, and the results, the output will give us economic benefits. Sometimes we have a question, what is more important? Competence, motives, values, qualifications, and intellect. Everything is interconnected. Everything is linked by us. I will explain why. The values determine the usage of intellect, because if the person has got a destructive value, then the intellect will be used to destroy. And if we say that we compare competences and values, values are more important because the behavior will be always linked to the values. But in critical situation, the personal attitude will come up because he or she will not be able to do something in contradiction with the values. So motives. So what are the principles in life taught by parents? The qualification, same. Strictly speaking, usually we used to look at the qualifications like 5 years or 10 years it takes for training and to get a certain qualification, but the world is changing so fast. The laws are changing so fast. So we have to understand to have intellect than strict knowledge of the laws. You have to interpret the laws correctly and to have values to enforce a law, to make it just and to make to interpret it in the right way, but not in the best interest. So we are using different. When I say we, I associate myself to the High Judicial Council. We have the multi-tier system of selection, and it's great because we want to ensure validity. When we choose 10 judges, we want all 10 judges to be fully in line with our expectations. But this can't happen in reality anyway. Even with our multi-tier approach, there will be an error, and the 3 judges will not comply with our expectations. What does it mean, validity? Validity is just the God. Only God knows what will happen in 10 or 15 years. And validity 1 says that out of 10 judges, all 10 are compliant. And there is respected international companies that uses the graphology, but the validity is very low. So we need to combine different approaches to improve the validity of selection. And the assessment center mentioned by Nikolai, it's an important thing. Testing, of course, it's important. And we have to sum it up together. But what can we say today? Speaking of interviews, there is no point of having a CV interview. You don't need to ask people, where did you work? You can find it in the internet. You can find it in the profile. But we do the competence-based interview. But for positions that are not that high, judges are different. There is a district judge, city judge, and so on and so forth, or Supreme Court. So higher the position, then these people are more competent. And for competent people, the competence-based approaches wouldn't work because they know how to behave in typical situations. You have to do something else to them if we want to evaluate their qualities. How to evaluate values? Well, our life is finite, and we have to assess different situations when we interview or give them cases to solve. Let him or her make or tell us what decisions were made in certain situations. What does it mean to swing the interviewer? We have to ask the questions in the correct way. If you want to measure values of the person, of course, people's experiences are unique. All people have got their personal stories. By the way, I don't believe in the story that you can prepare a guide or list of questions and ask them mechanically to all people. It doesn't work like that. This mechanical questioning is not effective. We all have different qualifications and we interpret answers differently. But we need to analyze the profile and experience before the meeting very well to see where there were failures in the career, talk about failures, see what happened in person's life in different periods. And of course, to plan the questions in advance. And during the interview, when you are observing them, you have to act correspondingly. I will give you an example, how it works, how to assess the values. We don't have the list of questions for interviews. It doesn't make sense. We teach how to assess, including the leaders, because the leaders have to be chosen and their subordinates. These are 4 values of our portfolio companies. I'll give you an example and you will see how this mechanism works. In 2003, for the first time, I came to the Republic of Kazakhstan. Astana, it was Astana, not Nur-Sultan. It was the heritage of the Soviet Union. There was one bridge above the river. I remember Ramstore supermarket, and there was a building looking like Gazprom. I am from Moscow, so it was quite curious. In 2003, I met a person. And years passed, I met this person, and I was interested what happened to him. And I asked him, could you please tell me, for these 10 years, did you have anything, any situation when you could do something very valuable, not just for yourself, but for the society? Did the life give you such a chance for these 10 years? He thought and he said, yes, in these 10 years, I was the chairperson of one of the committees in one of the ministries. Why not long? Well, it turned out that way. Any details? And he told me when I came to get a job, I was interviewed and I was asked, what do you want? I wanted to change the attitude. And this was the tax committee. He was the chairperson of the tax committee. And he said, I want tax inspectors to be considered not as corrupt people, not as bribers. So I got all the leaders and I said, no one takes bribe. Who takes a bribe? I do anything possible, use all the connections to punish such a person. And then I leave as a person who couldn't do that. And I said that, and the journalist overheard that. So can you imagine that the country is large, the territory is large, and someone in the remote town got a bribe and he was caught, and then this person was approached and said, and he submitted the application. He said, I'm leaving, and the minister said, are you crazy? It's like your subordinate 10 levels down. It's his bribe, not yours. But he said, sorry, I gave my word. I didn't manage. And he shouldn't have taken the bribe. And if I lose respect to myself, then I will not be able to look in people's eyes. So it's a value. And when you talk to a person, you will see the values he or she has. Even in the childhood, the situations that we handled when we were children, how did we handle them back then? We will do the same now. The values do not change.
And what else? We need to also measure the desire, whether the person will not be burnt out. So when the person is at the high level under constant, continuous stress, it's very, very likely that they will be burnt out. But during the interview, they will say, oh, I'm going to be okay. So we need to validate and verify all of the data, while in fact, what we are interested in is not the energy. The more important is to understand the motivation, why he or she wants to be the judge, why he or she wants to be the manager. And when we talk about standard typical interviews, usually they start brainstorming. And what's interesting, the younger the person is, the more he or she talks that they want to change the world. And there are special hints for interview, and typically it says from larger to smaller. When he says, I want to change the world, you typically ask, what did you do in the morning to change the world? What did you do yesterday to change the world? And we always ask the question of why. Why do you want to change the world? And when he starts answering, you say another why, and then another why. So you basically make the root and cause analysis. You're observing and evaluating his behavior. Well, going back to the competences, indeed, we are using competences for the assessment of the judicial manpower, and Nikolai was perfect in elaboration on the competences themselves. But what we need to work on is that for a single competency, we need 3 working examples, 3 examples from the past, while one example, collection information on one example takes 5 minutes. It means that in order to assess 5 competencies, we need 90 minutes, and we don't have any other options. It means that we need to be very skilled in question making, while we have several forms of competences. And let me share the one that is used by the Samruk Kazna transformation team that we're using from 2017. And when we use the level-based framework of competences, we don't need to ask other questions. Just look on the screen. Well, let's call it model of competences adopted by one of our competences. Here we have leadership, and we have 4 elements of the leadership. You can see them. Responsibility, delegation, impact, and influence. So when we say the person is responsible, he has to know how to delegate and know how to push people and develop people. And then we have 4 levels. Not available, 0 level, level 1. This is typically throughput competencies for managers and subordinates. Then we have well-developed, number 2. And for judges of higher level, we have level 3, for instance. So when we ask questions, we are not based on the behaviors. We are based on the elements. Using this, let me give the example. Please try to remember some situation where you took responsibility, but very large one, and some of the elements were out of your control, and you had to delegate some part because you were not able to manage. And when someone was in disagreement with you, you had to push, you had to press on someone. So in one question, I have already combined 3 elements. So you combine elements, 1 element, 2 elements, 3 elements, and then our interviewed person, and then you use this model as a checklist. For instance, you have level 0, level 1, level 2, and 3, and you either understand whether the person is compliant or non-compliant or brilliant. Oh, that seems to be all for my presentation. I think that what's the most important for judges, that when we have people, not for judges' position, but just at earlier stages, we need to assess their intelligence skills. Just using the regular general tests, we can make a customized test or just the general ones, but we need to make sure that people understand what they are told so they can communicate their opinion. We need to assess their values at the very beginning, so not to invest in people whose values are not consistent with ours. And maybe all of this shall be done all together. It's good when it's great that we have such platforms where countries can share their experience. Thank you very much, Vladimir Hasanovich. Very interesting and informative presentation that makes us to think a little bit from a different perspective.